mention, my lord. I have pardon to mention, my lord. The petition.
For judgment, WBC 16304 of 2022, which WBC 16303 of 2020.
Having heard the case, we did find some infirmities in the selection process. In the instant case, this precedent underscores the need to focus the judicial review on whether the selection committee acted within its authority, followed the prescribed procedure, and avoided any procedural or substantive errors that could have led to an unjust outcome. Given the clear deletion of candidature from the select list, it is crucial to argue that this action could have been influenced by considerations extraneous to the merits of the case, thus falling within the permissible grounds for High Court to intervention as outlined in Gunasekhara. The deletion reflects an arbitrary and capricious decision-making process which would allow the High Court to scrutinize whether the selection committee's action were so unreasonable that no fair-minded authority would have arrived at such a conclusion. Therefore, while the High Court should avoid reassessing the evidence, it is within its purview to examine whether the deletion of the candidature violated principles of natural justice or was based on irrelevant factors, thereby justifying a review or correction of the process. The lack of transparency and proper consultation in the instant case, therefore, by all the opposite parties combined with the unaddressed vacancies reflect a departure from the letter and spirit of the IAS Appointment by Promotion Regulations 1955. The exclusion of provisionally included officers and non-consideration of the petitioners who could have been next in line for promotion, potentially impacting their rights and promotions without properly addressing the vacancies, coupled with the lack of proper correspondence and consultation, suggests a procedural lapse and a failure to uphold the fair and transparent process mandated by the IAS Appointment by Promotion Regulations. In the backdrop of the discussions above, the opposite parties are directed as follows and must comply and shall comply within a period of 90 days. The EPAC shall convene a review selection committee, ensuring that it is constituted in accordance with the letter and spirit of the Promotion Regulations 1955, and to conduct a thorough review of the procedural compliance, including the documentation and consultation amongst all the opposite parties as mandated by Regulations 6 and 10. The review selection committee shall ensure that the vacancies identified are accurately represented in the review process and that the next eligible candidate from the merit list are considered for those positions as originally required. The state government shall ensure all necessary compliance, enabling the review selection committee to grant benefit retrospectively, made with motional or other petitioners as would be befitting to the respective cases, and do not adversely impact officers who were already promoted in previous selection unless such a change is warranted due to legal directives or the rectification of errors in the selection process. Upon the conclusion of the review, the central government shall promptly issue appropriate orders as the case may be in accordance with the recommendations made by the review selection committee. As a corollary, the impugned orders in both the cases in OA 308/2021 and OA 309 of 2021 passed by the Learned Central Administrative Tribunal Cuttack bench are set aside. Both the writ petitions are accordingly allowed.
I agree. Most obliged. Item 35, my lord, behalf of S.K. Patnaik is hospitalized and I has a so time में भी मला आता क्यों नहीं कुछ 35 my lord.
32.
35, it is WPC 21199 of 2024.
My lord,
Hira Begum, you want adjournment
adjournment, my lord.
till?
1 month, my lord. There is a hospital and person
Is there any interim order passed?
no, my lord.
All right. Mention is made on behalf of Mr. Sanjeev Kumar Patnaik for adjournment for 1 month since Mr. Patnaik is not well. Put up this matter after ensuing Durga Puja holidays.
28 of scholarships, my lord, at page 28. My lord, item 148, item 28. I'm sorry to trouble your lordship, my lord. Here the respondent is a retired, my lord, 73-year-old person who's in the disciplinary proceeding. My lord, all his retirement benefits were withheld. Now, my lord, in the CAT, in review, because this criminal case he was honorably acquitted, and on other grounds, they have allowed it. They have said that please give him all the retirement benefits. My lord, he's undergoing dialysis, this person, my lord. Now, my lord, railway is on appeal. The lordship has stayed on the last occasion. Lordship stayed the execution that I had filed in the my lord CAT. My lord, I only pray, my lord, it's directly my lord, governed by
Which item?
my lord, item 148.
140 is not.
40?
After
No,
145, it is 156. What is that?
Well, 140 at page 28, my lord. Page 28 of your lordship's. But only pray, my lord. Otherwise, I would have
No,
not made a.
the Union of India wishes to argue this matter.
Yes, your lordship, my lord.
Because
Now,
they are the petitioner.
yes, your lordship, my lord. Now they have taken a stay, my lord. I'll refer, my lord. Only.
Who wish to argue? Do not go. Why would you ask the land
So
council?
Raiguru was, my lord, already 5 dates have been taken by them for filing.
Ask Mr. Rayaguru, let him remain present. We can fix a date so that.
I have already requested and they are not
Yes.
doing it.
Item 29, my lord, at page 28. Similar matter has already been noticed and posted to 17th September, my lord. I have given a copy to the Royal State Council. Let the matter be put up on 17th along with this case.
Which matter?
Item 29, that is land acquisition matter. That has been
That
posted.
case also posted in
17th to watch.
item 29.
Or
Yes,
the
ma'am.
case where it was number of trees were
Yes,
selling.
well. A batch of cases is there. Similar.
And council petitioner submits that similar matter have been adjourned to one to date, and this matter may be placed along petitions. The land council for the state also submits that this writ petition is similar to so and so. Accordingly, is this matter along with so and so on such and such date you take that the fixation.
I have given the copy of the order.
All right.
Item 27, I have some personal difficulty but taken 2 weeks out and the petition is to negotiate the bank to close the loan. There's a negotiation going on and
What do you want?
I want adjournment for 2 weeks.
It up to
Item number 27.
27, madam. Ganesh Marana versus.
No, is there any interim order?
No, the fresh matter.
You want 2 weeks adjournment?
Madam.
The land council for the petitioners. Where the matter may be taken up after 2 weeks. Put up this matter after ensuing Durga Puja holidays.
Item 189 mentioned on Thursday to take up the matter. But listed today 189 item. Mortgage report has already showed that amount to be found. But Thursday I mentioned to take up the matter. But taken up
Which item?
189.
What do you want?
Tomorrow September matter.
No. What do we say on the last date?
Thursday they mentioned to take up the matter. Yesterday was holiday. How is it taken up? start for today, it is 189 item.
189, there is still defect that opposite party number 3.
Postal return,
So you have to file the fresh address of opposite party number.
already noticing address, proper address has been solved.
No, you do not know.
Proper address has been solved. That to be deemed to subject. That to we have no claim against opposite party.
You do not know. You have made a party, then
But I person to order of this one, I am made party, but no claim against it.
see that.
My period
Yes,
taken up.
next.
Yes. Pardon to make a mention, madam. On behalf of Mr. Mishra, item 58 and 62, maybe kindly 2 weeks after. He has some personal difficulties. Item 58 and 62 is a phrase matter and no entry model is there.
58 and 62.
Yes, your lordships.
You want after 2 weeks.
2 weeks after.
No entry model.
No entry model. Phrase matter.
All right.
Same page.
Puja holidays. Plan counsel for the petition of 6 per night winner for 2 weeks. Take this matter after ensuing Durga Puja holidays.
58 and 62, your lordships.
Same page. Item number 53. The client wants to engage a senior counsel. I pray Miller 2 weeks time.
You are the senior counsel. Why is the client?
Lord, I am not designated one.
Designated. Only designated.
Your lordship knows the mentality of the client.
Your years of practice and experience, you can be said as a senior counsel, may not be a designated one.
I am grateful, but your lordship, kindly.
You want adjournment.
Yes, 2 weeks time.
So, is there any interim order?
No, it's a fresh one.
Adjournment for how many weeks?
2 weeks time.
2 weeks. After Durga Puja holiday. Yes.
My first matter, item 8, and we have the Mr. Mahanti with the next week. Personal software. Next week.
Next week.
No,
It is urgent matter. Is there any order?
no,
Interim order?
no, first matter, no entry model.
Run counsel for the petition of 6 per an adjournment is next week. Is this matter next week? Yes. Yes.
The auction sale of the auction management is able to be held on
Give the memo.
real lordship. I mentioned real lordship allowed that memo. But
Trace admission method and another is after notice matter, the get dismiss my matter only grant.
My lord, CRL 517 of 2016, my lord. The petitioner is in custody since last 10 years. One paper book is
This is a matter.
my lord. CRL your lordship's restoration, order of restoration.
This is a matter where the transfer order has been challenged in the CAT and that has been dismissed and again they have approached. Pursuant to direction of this honorable court, we have to file an affidavit. I am appearing on behalf of the respondent. File an affidavit showing the vacancy position. We have showed that vacancy position since 16/7/2024 by filing an affidavit. But we are unable to fill up those vacancies. This school, Navodaya Vidyalaya school. Because
You wanted to list it. Give it.
pardon my lord.
Last time I mentioned his wife, patient wife is hospitalized, admitted in hospital. For which matter, sir, please to take up the matter.
Which item?
Item 189, my lord.
You have already mentioned. We said that there are, yes.
My lord, 194, item 194, for which time required for filing counter matter.
Yes.
Fresh matter, counter matter. 194, item 194. For which time required for filing counter matter.
Is there any order passed for
No entry matter, my lord. Only did
192?
194.
194?
My lord. Against the order of CAT, my lord.
Yes. Let us see what order.
The rejoinder is already filed.
WPC number, my lord, 17441, 2024, item 194. Ranjan Kumar Gedi.
Data item.
In that item, I got the petitioner line.
Council President.
He wants to file counter affidavit. That is why he seeks for an adjournment. It is, of course, after the notice was issued, it is the first date. So we are granting time to the you are Mr. Padi, Mr. B.K. Padi, London Central Government Council, 4 weeks time to file counter affidavit. Put up this matter after ensuing Durga Puja holidays. Counter affidavit, if any, be filed in the meantime, serving copy on the London Council for the petitioner.
My lord, another item 197, my lord. Already I have prepared the counter, my lord. Only 2 weeks time required for filing. 197. Radhakrishnan Sahu.
Is there any order, interim order, 197?
No, my lord. That is again the cat order.
Central. All right. The Mr. B.K. Padil and Central Government Council 6 submitted that he has received instruction in the matter and prepare the counter and file it within 2 weeks. And the matter may be taken up after 2 weeks. Put up this matter after ensuing Durga Puja holidays, counter affidavit if any. Like filed in the meantime. Copy on the Land Council for the decision.
Item number 2.
Item 2, my lord. Probably this bench, my lord Justice Das was a party in that appeal committee.
All right.
Probably.
Yes. In another way.
All right. Put up this matter. Attention which one of question Justice C.R. Das. Yes.
Item 3.
My lord, item 3, I am in virtual mode, my lord. My 3, my lord. Today the brief has been transferred, my lord. I have received the brief at today morning, my lord. May I pray, my lord, that can be taken up on Thursday, my lord. I will make myself
That is
ready.
there in the cause list, so we'll take up one list.
On Thursday, my lord.
12th of September 2020. From the
Yes.
week it will be called, okay?
My lord, because it's a bulky matter, so I have to go through it.
So,
Obliged.
Item 4.
Item 4, I beg your apology, my lord. On behalf of Learned Division, my lord, we pray for adjournment as his mother has expired.
you are making a mention on behalf of
Shri P.K. Padi, Learned Division, ma'am.
whose mother has expired?
Learned Division. He will apply his lordship.
Mention is made on behalf of Mr. Padi, who is Deputy Solicitor General. If there is a bereavement in the family, the matter may be adjourned for 2 weeks. Please this matter. Comments. Yeah. The London Council for the opposite party or for the opposite party is present.
Item 5.
Under the last occasion, your lordship directed the State Council to obtain instruction as per order dated 15/7/2024.
Mr. Misra.
My lord, this case, my lord, actually directly given to state government. It is not the state government because railway is a party. Railway has to because my lord, Government Department 6 also. So central
What is the relief claim for? Acha, relief for awarding compensation for acquisition of land.
land. That is why the railway.
What project has been?
The special acquisition officer, Tajtari, once per year railway project.
Okay, then it is the Union of India.
My lord, Union of India no rule. Direct my lord, collector has a man rule.
Yes, as arbitrator.
Collector office. And not this case, my lord.
Has he moved to the collector?
Yes, ma'am. Your lordship kindly have a glance. Unnecessary 5. I have ventilated my grievance before the collector. Keonjhar. Thereafter,
Previously, there is an order number 1 which was passed on 15/7/2024. There was a direction to the Land Council for the state to obtain instruction regarding the developments which has taken place after 15/4/2024, which was the date fixed by the Special Land Acquisition Officer for hearing the persons who are alleged to have taken away the compensation amount, being not entitled to get the same, as having sold the land in question to the petitioner. And if the sale was after the date of notification under section so and so, when the prohibition contained under section so and so was enforced. So that is why we asked you to obtain inspection.
because that order matter to state council, it should be the council of the union, because this is project of the under the railway matter. So they are supposed to give this.
It's all right, but your officers, the state officers are exercising the jurisdiction. So you can take the instruction what is there. Whether, but the officer is your state officer. Of course, yet they are dealing with the compensation matter. So this instruction was, the order was passed on 15/7.
Let me next week because the railway is the concern of project matter. That's why we have not obtained matter.
No, if the collector hesitates, we can ensure his personal appearance here.
We have not asked the collector matter. Let him next week.
This was to be brought from Special Land Acquisition Officer. He had called for the hearing. That is why we asked about that.
The Land Council for the state seeks for an adjournment till next week to obtain instruction as per the order dated 15/7/2024. Court of this matter will be commencing from 17th September 2024. Land Council for the petitioner is present.
Our appearance been noted in railway.
Mr. B.K. Padhi, Land Central Government Council is present. Okay.
Item 6.
Yes,
Mr. Das, why don't you use, we have for your convenience, if somebody may assist you, there is no problem. Please use it so that let us see, it is very easy, there is no problem.
Yes, I know, but
No, if you can, you begin it, let us see. Inconvenience is very.
Unless you put your hand on it.
difficult to is.
You see how it is easier.
The marks I have made.
That you keep side by side, there is no problem, but just this is item number 6. Otherwise, it will just remain as such without any use. And
as a table.
हाँ
Yes.
तो तापर आपण तापर फाइन पकेइकिनि सेटू व्यवहार करिवे तेणु सेथिपाई
And this case, this order of recovery of salary, recovery from the salary of the petitioner is the subject matter of challenge only with the stipulation
Made in Annexure 2, a government resolution.
you are challenging annexure 10.
My lord, yes. All these persons, the background of the case is like this, my lord. All these persons were appointed and retired from government service in different district office, the district courts. So after retirement, on opening of this fast track special court, a rule came in 2020 allowing those persons to work on remunerated basis in the POSCO courts or something like that. On consolidated basis. Yes, not consolidated, but that is the issue, my lord, in this case. Kindly turn to the clause 6.2, page 18. Annexure 1.
No,
that in fact they do not have any lien with their private previous post. It is altogether no. Only thing here is in this case no service condition. Only this salary. Yes. Kindly see, my lord, 6.2. That is what is consolidated. A retired salary, read, my lord. Pay and allowances.
You are placing page 18.
Page 18, 6.2. Yes.
From that. Page 18.
Yes. A retired ministerial staff or Group D employee on appointment under the scheme on ad hoc basis shall be entitled to receive pay and allowances all the rate she was drawing at the time of retirement minus total amount of pension being received by him her after commutation under the pension rule applicable to him her. He shall also be entitled to all other regular allowances admissible to in-service staffs of the respective cadre. What does it say, my lord? Whatever my salary is there, it will be protected. If I will join in some other post, whatever the pension I have, that will be minus from the student. Suppose I was drawing pension of 20,000, but I joined in a post where the salary is 30,000. What I will get is 10,000 because 20,000 is my pension. That will be deducted. But this was subsequently amended in Annexure 2. When you see, 20, that is at page 20. The first part is almost same, my lord. But the proviso, next page, is 21. Here is the dispute. Provided that with regard to fixation of pay of a retired employee on re-engagement against the lower post than the post he was holding at the time of retirement, and I am giving a passation, and who has retired prior to 1st January 2016, the pay shall be fixed invoking the para 5 of that government resolution, Cooperative resolution 29 September 2022. But it says if these two conditions are there, if you are appointed in a lower post, you are continuing against, suppose, a head clerk, joined as a junior clerk, and he has retired prior to 1/1/2016, he will govern under this Cooperative resolution 2022, where it says there is a slab, fixed term, 20,000, 10,000, like this. That is I have given. So that will be the first part of the what I have read to my lord. The original it was there, minus the pension you will get whatever you are doing. That is taken away. My respect submission is all these petitioners, the distinction and subject to my lord's approval here only, all these persons joined in a lower post. That is one part of the thing. But it says that and who is retired after 1/1 prior to, we are not retired prior to 2016. We retired after 2016. So what will be the consequence? My respect submission had this word end would have been substituted by or, then the stand taken by the authorities is correct. But these two part of this proviso has to be read together. Only one, if I joined in a lower post, admitted. But since I have retired after 1/1/2016, this has no application to me. That is my whole submission. That is why in batch of cases has also been admitted and matter has been posted, no counter filed.
Well, which is those connected cases?
Connected cases, my lord, 35617. I have filed these 4.
Just one, give the number.
I will give a slip. These are the 4 cases I have filed.
The
No, Asuta.
Mr. Samit Kumar Das, Land Council appearing for the petition of as a lecture where is made like this one. Petition of similar matters are sub judice before this court in swan so in which the opposite party has been asked to file counter affidavit. But the counter affidavit is yet to be filed. No?
Yes, ma'am.
एवढा किसी डेट फेट फिक्स अप ହେଇଛି ଆଦରେ
ନା ସେଟା ଖାଲି ନୋଟିସ ଏଇଟା ଡେଟ୍
Please
ଫିକ୍ସ
this matter issue notice କରିଦେବେ ବାକି ଯାହା order application ଗୋଟେ order କରିଦେବେ is this matter along this one ତା ଦେହରେ ଯୋଉ order ହେଇଥିଲା ସେଇଠି କରିଦେବେ issue notice on the question ଅଛି ଯାହା
କାଇଣ୍ଡଲି ଫିକ୍ସଡ ଡେଟ୍
ହଁ ତା ଦେହରେ counter affidavit file ହେଇନି
ନାହିଁ।
ଏବେକାର ସେ matter ଗୁଡା
ଏଗୁଡ଼ା 23 ମସିହାର ଦିଟା ଗୋଟେ 24 ମସିହାର
so 4 weeks ଥାଉ issue notice କରିନା issue notice କରିବେ ବାକି ସବୁ ଯାହା systematic କରିକି reference back କରିବେ
Item number 7.
Item 7, in this case, your lordship, petitioner have filed an IA for amendment of the writ petition incorporating 2 documents.
देखिए argument
Yes, sir.
एक सीधी जाओ चलो ठीक है
हाँ।
be there
ठीक है हाँ
yes what is this interim application
interim application for incorporating 2 documents, your lordship. One document which has been received by the petitioner after the order has been communicated to him, that is annexure 7, your lordship, that is page number 7 to 11.
and thereby you are incorporating some paragraphs in
Paragraphs, your lordship, that is in the schedule, your lordship.
yes Mr. any objection or like IA number is an application for amending the writ petition. Copy of the interim application has been served on the Land Council for the state. There is no objection to such amendment accordingly. Prayer made in this interim application is allowed. The paragraphs mentioned in as per this schedule now shall form the part and parcel of the writ petition. Consolidated writ petition to be filed within 2 weeks.
3 days.
Within a week, got me. Serving copy and
Okay.
Land Council petition.
A date may be fixed, your lordship.
File it
Obliged.
due time.
Obliged, your lordship.
I don't dispose of for the
Obliged.
Item 8. Item 9.
May I please?
Look at here and up. Keep your file side by side, but look at both. Yeah.
Annexure 24, my lord, page 55. That is the order dated 5th June 2024.
Just a minute. Come to order number 1, 6 for an adjournment to which both the ratio laid down in Swan. And council president 6 for an next week to file the state took time. So, opposite party took time to file counter affidavit for petitioner 6 for an adjournment next week to file the counter affidavit filed by the opposite party before the Central Administrative Tribunal. So also the rejoinder affidavit which has been filed by the petition.
That I have already filed, along with my additional affidavit.
Yes, who is for the Union of India?
Mr. Kashyap was appearing in this case.
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ ମ୍ୟାଡାମ ଆପଣ ପଛରେ ଥାଆନ୍ତୁ
ଦରକାର ହେଲେ
ଦରକାର ହବ ଆପଣ ଆସିଲେ କି ମଝିରେ
Madam, extremely apologetic, my lord. There is a bereavement in my family. Your lordship may kindly allow.
we are told that so let us see, there is a bereavement in the family
My
of
lord.
Mr. Party, so we take him off after 2 weeks. Okay? The Land Council for the petitioner submits that as per the order dated 2/9/2024, he has already filed the counter affidavit filed by the opposite party before the Central Administrative Tribunal, Cuttack Bench. So also the rejoinder affidavit filed by the petitioner. So they are available on the form.
My lord, only there is a noting in the cause list.
And copy of the same has
I have already served.
served on the Land and Central Government Council. Stop. Mention is made on behalf of Mr. Party that there is a bereavement of the family. Matter may be taken up after 2 weeks. 2 weeks for
Oblige me.
Diplomat.
Item 10,
Lordship, in item number 10, kindly be taken up 1 week after Lordship. Goods and personal difficulty of
You are mentioning on who here?
Petitioner.
Petitioner or opposition?
Okay.
Petitioner.
Okay.
You are for the
And for
opposition.
the bank here, this is, I'm not objecting to the adjournment. There is no solution to this problem unless they come to something. So their problem is that the property is mortgaged. Now they are saying that let the property be sold and the money be paid to bank. So they are seeking NOC from the bank. So it's like without payment, bank cannot issue NOC. And I understand without NOC, they can't sell the property and pay the big amount. So the solution is that they can get a buyer of their own choice, get to the bank. There should be a tripartite agreement, seller, buyer, and the bank, so that the sale proceeds comes to the bank directly. And if there is a surplus, he will get the refund. If there is deficit, he can make the good and take the NOC. Otherwise, he also can't sell it, and this will go on for the.
What do you say?
Your Lordship, I will take instruction from my client, Your Lordship. I
That
will
is
talk
your
to him.
case?
Your Lordship.
All right, the Land Council for the appearing for the ICICI Bank, Mr. Panikai submits that the matter can be sorted out if the petitioner arrange a buyer for the land in question, so that the amount recovered or amount of the purchase amount can be adjusted towards the loan granted in favor of the petitioner by the bank. The Land Council for the petitioners seek for an adjournment to obtain instruction in that respect. Put of this matter to be commencing from 23rd September 2023.
But a small suggestion, the Lordship has mentioned that the sale proceeds can be adjusted through a tripartite agreement.
item 11,
Use that.
But here the petitioners are the retired employee of the lower judicial service matter. That after retirement matter, there is a under annexure 1, there is a on page 9.
Yes.
There is a government resolution that the retired employee also included in the as per the direction of the Honorable Supreme Court from upgraded from level 9 to level 10, and accordingly they will be eligible for consequential benefit, financial benefit. And from the date of the functioning of the court or from the date of
or 1 for 2020.
So you have
2003.
submitted a representation.
My lord, under annex, and my lord, in the meantime, other judgeship, my lord, I got the yesterday, I got the copy. Other judgeship, my lord, they have complied the.
So you have not received any communication from the.
No, my lord, we have. This is the my lord from Baud and from the district of Baud, Balangir, and
They are made like
Balbani.
Submitted that
Lordship,
the basis of annexure 1.
only
A
glance.
representation has been made to the district judge Keonjhar since 16/1/2024, but he has not received any communication from the land and district judge. The land council for the petitioner also brought to our notice that similar relief has been granted in the
In other justice.
in other justice. He has filed the documents in that behalf which have taken up record. The land council for the state has no grievance, no objection to such relief. Representation is to be disposed of within a period of so and so 3 months order, and the order we communicated the usual order. Yes.
Item 12,
My lord, Lordship's order 12/8/2024, initial order. Thereafter, Lordship's also second order. It is descriptive in order dated 12/8/24. The paragraph, my lord, 6. It is further contention of the Lord and Council for the petitioner that, in spite of the order passed by the Railway Board on 7/2/2020, the petitioner is yet to get any promotional order from the competent authority, and in the meantime, he has been superannuated. So, the order of the, my lord, the tribunal
will be given some time to obtain inspection as to why the order passed by the Railway Board has not been carried out, and the promotional order has not been issued in favor of the petitioner, even though more than 4 years have already passed since passing of the order under Annexure 6. So that is the order. Then when it was taken up 2/9/2024, Mr. Kochayat, Learning Central Government Council, 6 for an adjournment, and accordingly, the adjournment was granted.
Today we are filing the preliminary counter affidavit. Today we are filing the preliminary counter affidavit, madam.
Okay. Give a copy.
I'm serving the copy.
Land Council for the Mr. D. Kochayat, Learning Central Government Council, files the counter affidavit, which is taken on record. Copy has been served on Mr. Mahanti in court to seek some time to go through this matter. Week after, let it come. If you want to file any rejoinder after going to the counter, you may file. Weeks after, for example, rejoinder affidavit, if any, filed in the news. Yes.
My lord, it has not been notarized. I'll file it in the today. Yes. I'll file in the postal.
In course of it.
In course of the day, file will does what the cutting of it. We file the counter of the David Swans. We solve these swans for them. The claim will see some time. We'll file it in course of the day.
item 13,
item 13, the petitioner.
What is your prayer?
My lord, in this case, during the pendency of an partition suit, one of the co-borrower has taken loan from the bank, and the details of which are not known to us. And during the pendency of the suit for partition, he has defaulted in his payment, and the bank has taken measures under the SARFAESI Act. So our prayer is to
auction sale notice has been issued.
Auction sale notice has been issued.
So what was the date fixed?
As per our information, this has failed. As of now, this has failed.
So, what relief you want further?
My lord, the law is well settled that during partition, the status quo of the property has to be maintained. So,
Go to the appropriate forum and challenge this. You have already approached the civil court, I think.
civil court was approached prior to the measure taken by the bank.
All right. So now, since this auction has failed,
Yes.
you can negotiate with the bank or whatever it may be. This court cannot entertain these surface matters. Let them do. It is stated by the land counsel for the petitioner that the e-auction sale, which was supposed to be held as per Annexure 3, has failed. And a civil suit is also pending by its CS number so and so in the Court of Additional Senior Civil Judge Ajpur. The petitioner seeking for a direction to the opposite party number bank not to create any third party interest over the suit civil property till the disposal of the suit for partition and allotment of share by the land and civil judge. Since alternative remedy is available, so actually you are not inclined to entertain this also accordingly disposed of. Yes.
Item 14.
The common application which was filed in the original application, that is before Lordship's board. The improved order has been.
Just a minute.
Well.
If we go to the order dated 12/8/2024, look there. 12/8/24 order देखो.
Yes. In the opposite facts and circumstances, the petitioner humbly.
You are reading order dated 12/8/24.
Order dated.
Previous order will be there. Yeah.
Previous order is there. 12/8/2024.
I'm not.
Mic adjust from.
Yes. 12/8/24. Matter is taken up through us. So the petitioner has filed this petition challenging the order dated 21st November 23, passed by the learned Central Administrative Tribunal Cutoff in OA number such and such for a direction to the opposite parties to release the arrear salary of his father for the period from 1/12/99 to 36/2022, and also to provide employment assistance to the petitioner in any suitable post to his qualification on compassionate ground in the interest of justice. On perusal of the impugned order under Annex 9, we find that on the ground of delay in approaching the tribunal, the original application has been dismissed. The arrear salary of the father of the petitioner for the period from 1/12/1999 to 36/2022 was claimed in the year 2023. Learned counsel for the petitioner submitted that in the original application, the petitioner has explained as to why there was inordinate delay in approaching the tribunal. However, he has not annexed the copies of the original application and the miscase for condonation of delay and seeks some time to file the same. On the request made by the learned counsel appearing for the petitioner, list this matter in the.
So did you file those?
Yes. I filed.
So what explanation that is the sole ground on which your original application has been dismissed, right?
Yes.
On the ground of delay.
Delay.
So how you have explained it?
My humble submission in my condonation application, I explained the delay occurring in filing the.
Where is that?
Yes, that miscase I filed, it is before Lordship's board. That is fluff.
Just a minute, let us see. That is MA. MA number 661 of 2020. Memo flat B টা ভাগ করো যে flat B রে আছে flat B ରେ ଏଠି memo ଦେଇକିନି ଫାଇଲ କରିଛନ୍ତି ସେ original application ଟା ଫାଇଲ କରିଛନ୍ତି original application ତଳକୁ ଗୋଟେ MA ଅଛି MA number 661 of 2023 Please read your grounds and that how you have explained.
Yes, Lord. In paragraph 4.
Read from there.
In paragraph 3.
Paragraph 3.
Paragraph 3 of my
yes.
Application. Paragraph 3, my lord, that is page 2 of the internal page, that the applicant being rustic villager, unknown to the law, legal procedure and limitation, repeatedly approached the respondent's relief authorities, ventilating his grievance with the hope to get relief by way of representation. He also communicated with the respondent to get information regarding the non-payment of the arrears salary of his father since 2010. Subsequently, due to the COVID-19 pandemic, the applicant is unable to approach the Honorable Tribunal in time, for which some delay has been caused in filing the present application. This is I have explained here.
So the period was from 99 to 2002, and you have not stated what you are doing till 2010.
Lord,
so
I beg your pardon, Lord. My father died in the year 2010. Since July 2010, my lord, my father persuaded the matter with the authority, my lord, and the learned tribunal has held that has not taken note of. That I was pursuing, that my father, deceased father, was pursuing with the lord. Apart from that, my lord, my humble submission, lordship, my lord, so far the arrears salary of my father is considered recurring cause of action, my lord. That the learned tribunal has not taken into account. My lord, my subtle point with your lordship would be that in case of such nature, where my deceased father was pursuing with the my employer, thereafter, my lord, the deceased wife, my mother.
Why that salary was not paid for that particular period?
Yes,
instruction yes. From my lord. But as per the petition, my lord, your lordship may kindly glance.
No, we go to the delay aspect.
I want only that delay aspect. The arrear he claims 2002 to 1990 to 2002, my lord. His father was alive till 2010, my lord. There is absolutely no material that why he has not applied for.
So you are again going to delay aspect. We are asking you a pertinent question: why the arrear salary from 1999 to 2002 was not paid?
That is have to take
this aspect will also.
Well,
so what he said that the father died in 2010. He was all along pursuing the matters. Maybe he has. He was hoping that he will get the relief. He has not, but after 2010, maybe that it is in that way he has not explained. But if you do not have any genuine ground for depriving the father of the salary from 99 to 2002, it is almost 2 years. 2001, 2000. No, it is 1 year and 7 months salary you have. So just take instruction why for that.
According to him, he was suffering from some kind of disease.
Yeah.
Whether for that he has properly taken step.
Voluntary retirement was given.
On which we do not know because the ground. The ground is that for delay it has been dismissed. Suppose we think that these are the he has got a good case, but on the a ground of delay should not be defeated because the man is dead and ultimately. So just get that instruction.
Next time, Lord.
In persons of the order dated 12/8/2024, the London Council for the petitioners has filed the original application also the miss case for condonation of delay which was filed before the Central Administrative Tribunal. Copy of the same has been served on the Land Council of London Central Government Council, Mr. Jaina. After perusing the original application, so also the Miss MA, which was filed for condonation of delay. When a query is made to the Land Council, Central Government Council, as to why the arrear salary of the father of the petitioner for the period from 1/12/1999 to 36/2002 has not been paid. The Land Council, Central Government Council, seeks for an adjournment to obtain instruction in that respect. Put up this matter.
I'm not adequately.
Yes.
Yes, sir.
Item 15,
Please, Lord.
15 million.
Surface area.
Appropriate order on the application under section 14 of the Surface Act.
Just seeking a direction to the district.
When that application was filed,
Lord, it was filed on 28th of November 2023.
you have not received any communication.
No communication.
So it is pending before the opposite party number 1.
Hello.
No, Chief Judicial Magistrate.
No, sir, authorized officer.
District Magistrate from Collector Puri.
Opposite party कितना हो?
Opposite party 1.
No. Opposite party number 1 is Chief Judicial Magistrate. It was either to be passed by the Chief Judicial Magistrate or the DM. But in this case, it is Chief Judicial Magistrate. Is it pending before him?
This
it is
come to that
wrongly typed. It is actually
come to
district
the annexure 1.
Yeah, it is district magistrate wrongly typed.
Wrongly typed.
Accept my
Annexure 1,
mistake.
it is before the district magistrate Puri.
Yes, that's the annexure 1, the
So
14
the
application.
concerned district magistrate has not been arrayed as a party. So how can you get the
I'll
relief
amend
unless
it.
you amend it and all right?
I'll amend it.
The London Council for the petitioner seeks for an adjournment to file an interim application for amendment. Put up this matter after the interim application is filed. Yes.
55 also same matter.
55.
Identical matter.
55.
Hmm.
55 also same one.
55 there is no amendment. So I'll wait for the turn otherwise. I'll wait for the turn. There is no amendment in this item 55, but similar matter.
Acha, this matter be listed along with 55.
Yes.
We are not passing, we are just passing the order. In this matter, you have to amend it.
Well,
You can let them forward a copy also.
55,
Let
15.
a copy,
I'll
let a copy of the petition, so also the copy of the interim application, which is to be filed, be served on the Land Council for the state.
week's time may be given, Millard. I'll file it immediately.
No, we said that the moment you file it.
The I will be list. Obviously.
Right. Yeah.
item 16,
Forward.
Item 16, 33, 39, 70 and 71.
Just a minute. 16 then
16, 33, 39, 70 and 71.
With all.
16, 33,
33.
39,
Yes.
70,
7
70.
70
70. Yes.
and 71.
Eh?
And 71.
71. Annexure 4 in that.
Annexure 4. That would order for 2 years. Annexure 4 is the right.
What's it?
Annexure 4 is the church. Next.
Item 17.
Please, election manager. I'm challenging. I'm challenging the order of the tribunal passed in way number 26 of 2018, dated 11/10/2023, my lord. The short question before the lordships, my lord. The interpretation of the tribunal in respect of the so far the office, the stopgap arrangement for the petitioner in the post of principal chief income tax commissioner for the period of 3 months, whether it is coming under the purview of FR 49(1) or under FR the fundamental rules of 11. The case of our respondent, the Union is concerned, my lord. Only a stopgap arrangement he has been appointed to that post. Though he is holding the post of chief income tax commissioner at that point of time, while transfer from Bombay to Bhubaneswar, a stopgap arrangement has given for 4 months, my lord. But tribunal holds that it is the applicability of the fundamental rules of 49(1).
What the applicant was claiming.
He's claiming, my lord,
his
transfer.
Okay.
He's asking for the scale up to PCCIT for the period he was officiating.
Yes. But the question is, my lord, that stopgap arrangement has been made, but no official order has been issued by the department. As per the notification and the memorandum of the government of India, if a person is holding for officiating, that to get that salary, the approval of the
Very that order by which he was asked to officiate that.
You also may kindly see annexure. That is the his petitioner annex enclosed to that application. You also may kindly see 61
in the original application.
Yes, madam.
Look at there.
To get the answer. Yes, 61. Thank you.
You are placing page number 61.
Yes, my lord.
Okay.
That it is started from 60. You will also kindly see the different one is promotion has been made. Order by order. Page 60.
20th.
Composite order passed in respect of all throughout India.
20th September 2016.
60, my lord.
Right.
You will also kindly, so far as petitioner is concerned, you will also
just heading the order number 164 of 2016 pore jota lekha hai page 6
following officers in the grade of principal commissioner of income tax that he pay scale of so pre-revised are hereby promoted at ad hoc basis to the post of Chief Commissioner of Income Tax in the pay scale of rupees 75,500 to 80,000 pre-revise. For the panel year 2016-17, with effect from the date of assumption of the charge of the post and until further order, the officers being the granted ad hoc promotion will be considered for regular promotion to the grade of Chief Commissioner of Income Tax only after subject to promotion of their seniors to the grade of Chief Commissioner of Income Tax. It is in respect of those 1 to 30, my lord. First page, my lord. Second 2, lordship may kindly see.
No.
I am in coming under 4, my lord. Serial number 4. Lordship may at
Serial number
Apart from the above.
yes, ma'am.
Apart from
the above, the following transfer is not been promoted. Is transfer posting in the grade of CCIT are also hereby ordered with immediate effect until further orders. The Chief Commissioner of Income Tax, he is holding that post. You will also make kind of page 3, serial number 3. The respondent or applicant, he posted to Bhubaneswar to hold additional charge of principal chief to her Bhubaneswar. And he is subsequently retired and claiming the charge of that to hold the post he is holding. As officiating, he demanded that amount, my lord.
So his substantive post is CCIT.
CCIT, yes, ma'am.
And after the transfer, he was asked to officiate against the higher post.
Yes, ma'am.
So he is claiming the scale of pay of the higher post.
Yes, ma'am.
So what is the rule?
What is your
that you also may kindly so far the tribunal so that there is 2 provisions so far as dealing of this FR 11 and FR 14(1), my lord. 14(1). You know, that has been quoted by the learned tribunal. You will also may kindly see that.
Okay, that is in page number 37. 37 number page
37. Yes. If unless in any case it be otherwise distinctly provided the whole time of a government servant is at the disposal of the government which pays him, and he may be employed in any manner required by the proper authority without claim of additional remuneration, whether the service required for him are as such would ordinarily be enumerated from the general revenue, from the local fund or from the funds of the body incorporated or not, which is wholly or substantially one uncontrolled by the government. Our case is that is coming under purview FR1 when specific order has not been issued to officiating that post, and FR 14(1), where a government servant is formally appointed to the full charge of the duty of a higher post in the same office as his own and in the same cadre line of promotion, in addition to his ordinary duty, he shall be allowed to pay admissible to him if he is appointed to the officiating in the higher post, unless the competent authority reduces the officiating pay under Rule 35, but no additional pay shall, however, be allowed for performing the duty of the lower post.
No, is it a same cadre?
No, my lord.
Then how do you say that FR 49(1) will be applicable?
It is the case of the applicant respondent that the 49(1) is applicable. Our case is that one as a stopgap arrangement, he has given to additional charge of principal chief income tax commissioner. This is not entitled. And what happened in this case, my lord?
Just a minute. Same office as his own, and in the same cadre so on. So, in addition to his own, he shall be allowed to pay admissible if he is appointed.
By dealing with that, now that is a circular of the government of India that how to deal with rule FA 49(1) I and I3, my lord. You will actually that is at page 78.
No, this third, fourth line is very important. You FR 49(1)
My lord.
where a government servant is then in addition to his ordinary duties,
Yes, my lord.
है ना? He shall be allowed
To pay
to pay
admission
admissible to him if he is appointed to officiate in the
higher
higher post. So, admittedly, he has been asked to officiate the higher post. So, that is exactly what he says that FIR 49(1) would be applicable to him. But you
Well,
say that no, it is FIR 11 would
But
be.
my respective submission would be,
Yes.
so far as the officers who have been holding for the officiating post, a special order has been issued by the government of India with due approval of the person and grievance department.
DOPT.
DOPT, my lord. As for the circular, I have annexed that has been also annexed by the petition in OA at page 78, which stipulate to give remuneration of that post, a specific and approval should be set for from the DOPT, my lord. And in this case, only due to stopgate arrangement, he has given to hold that post for 3 months. That is why we denied. And what happened in this case, my lord, he himself allowed to take the higher scale of pay of January 2017 with order of that principal CPIT, my lord. Chief Commissioner himself, he passed the order and obtained the salary of January 2000. His grievance is that he filed application and representation for arrears salary.
It's not a case of formally appointed to
Exactly, my lord. Exactly, that is
but
our
only he has been
additional charge.
Formal appointment was not.
That has been your lordship further clarify. If your lordship look at the page 78, this is the circular of the government, which has been.
But what the tribunal held ultimately.
Tribunal held that he is coming officiating and continue to work as a principal chief income tax commissioner, and he is entitled to get the
49(1)
yes,
applicable.
yes.
Right. It is coming for the first time.
Yes, madam, first time.
All right. The petitioner for the have filed this writ application challenging for quashing the order dated 11/10/2022 passed in way number so and so by the Central Administrative Tribunal bench unissued one. The Central Government Council, Mr. Maharna, submitted that the original application has been filed by the opposite party, Vijay Kumar Misra, for a direction. Have you got that original application with you?
Yes, madam. That is annex. Annex 2, madam.
With such and such relief, say you original application लिखा है जी, है ना?
Had the
Relief sought for लिखा है जी, page number 57, है ना? The Land Central Administrative Tribunal has been pleased to allow the relief sought for, taking into account the provision of FR 49(1), which reads as follows. Quote FR 49(1), that is in page number 37. It is the contention of Mr. Maharana that since the petitioner, since the opposite party was not formally appointed to hold the full charge of the duties of the higher post of what is that called?
Principal.
PCCIT.
PCCIT is not entitled to get the relief in as much as the order কোটি annex କରିଛନ୍ତି ସେ ଯୋଉଟା ଦେଖଉଥିଲେ ଆପଣ page number କେତେରେ ସେଟା ଅଛି
61 ଦେଖୁଥିଲେ ନା?
Yes, madam.
He has been ordered to hold the additional charge of PCCIT, Bhubaneswar, which should be evident from annexure
One series of the original application.
Later from the order number 164 of 2016 dated 20th of September 2016, which is annexed to the original application. With the impugned judgment, impugned order passed by the so and so. You should notice on the question of admission indicating there that the matter shall be disposed of at the stage of admission. The requisites for issuance of notice to the opposite party express court report delivered shall be filed within a week. Like Marana is filed within a week for issuance of notice. Matter to be listed 4 weeks after. Counter affidavit, if any, will filed by the opposite parties in the meantime. Yes.
Madam, I hear in notice to them.
I know what stay of operation of
Yes, madam.
IN number one, so as an interim measure, hard for the one, interim measure, the order dated, the operation of the order dated so and so, passed in so and so, under annexure one, shall remain stable until further order. Yes.
Obligation.
Item 18.
Please, Your Lordship. 18. Here the copy of the notice dated 23/7/2024 under annexure 9 is under challenge, Your Lordship. Issued under section 13(4) reduced section 8(1) of the Securitation Act against the petitioner. May I take Your Lordships to the annexure 1. The petitioner case is that, my lord, he has availed a loan in the year 2007.
For notice you are challenging.
My lord, 13(4) reduced section 8(1).
So go to the appropriate
Taking possession, Your Lordship.
Alternative remedies available.
2007, the petitioner availed a loan of 2 lakhs rupees. I have paid
everything you can submit before the appropriate alternative remedy you avail and make your submission there.
My lord, the ground of challenge that they are not supplying the, my lord,
Whatever may be
account statement, as well as, my lord, I have paid 2 times of the loan amount.
alternative remedy available, disposed of. Yes, next.
Item 19.
May I please, Your Lordship? Annexure 9, page my lord, 31. The opinion number
19.
19. Annexure 9, my lord, page 31. The opinion number 4 rejected the OTS my lord proposal on the ground that my lords may kindly see as only the RCSO is having the power of that my lords, and that was my lords that
order was passed in view of, my lord, the order passed by this honorable court in earlier occasion, my lord. And therefore, my lord, I made an application under annexure, my lord, 8, my lord.
So they say that
Before the, my lord, the registered cooperative society, Odisha, my lord. That is pending, my lord. Lordship may kindly receive running page 30 as per 8, my lord.
it's
She's-
all right. You submitted an application
Ham korichi,
as per the direction of this court.
my lord.
Now they say in which the order which you are
31 in page
page 31
My lord.
that the bank has no authority to entertain OTS
Right.
on its own. It
Right.
only entertains OTS when registered cooperative society so grants permission. There is no permission so
Yes.
this one so.
And
So it is up to the now you have to apply before the
my lord, that is why, my lord, annexure 8, page 30, my lord.
Oh, you applied to register.
My lord, my lord.
That is pending.
That is fine.
when you made your application.
My lord, that is, I made an application on dated, my lord, 11/3/2024, my lord.
Date କିଛି ଜଣା ପଡୁନି
It date 9.
ସେ ସେଥିରେ ପକେଇ ନାହାନ୍ତି, ମୁଁ ପଚାରି
11/3
11/3/2024.
11/3/2024 ହେଲେ ଏଇଟା
That's the 19 ରେ।
ଏଇଟା ତ 1900 ରେ 24 ତାହେଲେ 1900 ପରେ ଆପଣ ଦବା କଥା ନା ତା ପୂର୍ବରୁ
ତା ପୂର୍ବରୁ ଦେଇଛନ୍ତି, pending ଅଛି।
pending ଅଛି। Right, this who is appearing for the other side? State. Cooperative society ପାଇଁ ଆପଣ ତ କିଏ ଡାଇରେକ୍ସନ ହବ ତାଙ୍କୁ ନ ଶୁଣିକି ଅର୍ଡର ଟା କରିଦେଲେ registered cooperative society this is pending before the registered cooperative society Odisha Bhubaneswar. Just put application dispose of the petitioner Srimati Sudipta Chan has filed this writ petition to quash the letter oblique notice dated 19/6/2024 under annexure 9. So also for a direction to settle the loan account of the petitioner as per OTS scheme. The learned counsel for the petitioner referring to annexure 9, which is the order dated 19/6/2024, passed by the authorized officer Puri Urban Cooperative Bank Limited, Puri, submitted that in the said later, the authorized officer has held that the bank has no authority to entertain OTS on its own. It only entertains OTS only when Register of Cooperative Societies Orissa grants permission. And since there is no permission of the registrar for settlement of the loans under the OTS, therefore, the bank would be constrained to proceed under the provisions of Surface Act for taking possession of the mortgage properties. Land counsel for the petitioner submitted that the petitioner has filed an application before the Registered Cooperative Societies Odisha Bhubaneswar for grant of permission for settlement of his loan account under Annexure 8 passed in WPC number 39961 of 2023 and other documents on 11/3/2024, but no order has been passed in the meantime by the register, even though 6 months is going to be elapsed in the meantime. And therefore, appropriate direction be issued to the registered cooperative societies Orissa Bhubaneswar to take a decision on Annexure 8. The Land Council for the state has no objection to such a prayer in view of the limited nature of grievance of the petitioner. The opposite party number 3 so and so is directed to dispose of Annexure 8 in accordance with law within a period of 3 months from the date of production of this one and communicate the other production. Disclose of yes.
Item 20,
Annexure 3, 20, Whitson is not disposed of.
Annexure 3 is pending.
3 is pending. The opposite party number 3, special land actions.
Annexure 3 is to be disposed of.
Sub item, your lordship's order, I have annexed to 3. Similar order.
Which will be detailed matter.
Take. We'll do it. I'm a corporate.
Dismissal notice for government, WPC 11429 of 2022.
In view of the foregoing discussions, we find no infirmity or illegality in the order dated 1/5/2023 passed by the Learning Tribunal in way number 222 of 2020 by Annexure 1. The petitioners were directed by the Learning Tribunal to refund the already recovered amount to the opposite party number 1, Anusuya Das, widow of Ramakanto Mishra, ex-superintendent of Post Office, Rayagada Division, within a period of 30 days from the date of receipt of the copy of the order. If the same has not yet been carried out, the petitioners shall refund the amount as directed by the Learning Tribunal within 15 days from today. Accordingly, the writ petition merits no consideration and the same is hereby dismissed.
I agree.
Yes.
Item number 21.
May I please, Your Lordship? The petitioner approached this honorable court with a very limited prayer, but in an extraordinary situation where I was sanctioned a loan behind my back by the bank, and the bank has completed almost all procedures and the sale certificate already issued against the auction purchaser. The thing is that, my lord, I have not availed the loan from the bank. And though I availed one loan at the 10 lakh rupees at the beginning, but thereafter they sanctioned a loan against me for which a FIR has been registered. And your lordship has rejected the bail petition of the bank manager. The bank has done nothing against the bank manager, but doing every bit to recover the loan. I am a very poor person. As per the direction of the Honorable DRT, I have cleared all the loan on by the order dated my order dated, my lord, 28/11/2023.
You are now challenging the order
Yes,
dated
my lord.
9/4/2024 passed by the
My lord.
DRT, right? So you come to that order. Let us see the 9/4/24.
My lord, that order is
Kindly peruse the annexer 2 of
Now we are-
October 25.
We are there.
We're there.
my lord. Honorable DRT has directed
Use that. Come to annexure 2, which is at page number 22. You said 22 or 23. 20. Come to 23.
23. My lord, the Honorable Tribunal has, by the impugned order has
Just
Check.
come to paragraph number 4. Page 24, paragraph 4.
Bare perusal of the impugned order will show that learned DRT has simply recorded submission of the learned counsel for the parties and recorded its satisfaction regarding existence of prima facie case in favor of surface applicant without assigning any reason. Such order cannot stand in the eye of law. Learned DRT should have recorded his finding with cogent reason while granting interim order that there is a prima facie case coupled with balance of inconvenience and irreparable loss or injury that would have been faced by the applicant if such interim petition is not granted. Without assigning any reason, impugned order was passed by the DRT, which cannot be said to be a judicial order, and said order is liable to be set aside. And accordingly, the order was set aside by the Honorable DRT by remanding the matter back to the Honorable DRT to dispose
No,
this.
the interim order was under challenge.
Yes, my lord.
So now it is stated that the main case, that is the essay number
essay
is
number
to be decided within a
129
specific
of
3 months.
All right. So
Not been
this order
decided.
was passed on 9/4/2024.
My lord.
So we are now in 5 months have already passed.
Yes, my lord.
So what is the status of that essay?
My lord,
ତାଙ୍କୁ ଅନେକ ସେ କଣ କହିବେ?
my lord, they were directed to obtain instruction.
ଆଜି
Bank.
ଆଗରୁ ଏ matter କଣ ଉଠିଥିଲା?
Yes, my lord. They were on the previous order. They were directed to obtain instruction.
ନାଇଁ order number 1 ହେଇଥିଲା non appeals on behalf of the petitioner is this matter. କିଛି order ତ ହେଇନଥିଲା ତାଙ୍କୁ କେମିତି direct?
Actually, it pass over uthila, but their counsel is not present at the time.
Right. Have you taken instruction? What is the status of that case? Essay number so and so before DRT.
My lord, it is still pending.
Yes.
But any modification of order made by them, so they will approve the DRT. Ma'am. This is the
Mr. Counsel, there was a direction to dispose of that main petition. Okay, interim order, it was challenged and he was asked to, there was a direction to dispose of the main petition. So SA number 129 of so and so along with IN number within a period of 3 months. Since that period has elapsed, that is why we want to know from you that, so that is your instruction that it has not been done. So we can direct that it is to be disposed of within a particular time. This petition has been filed by the petitioners Sudhanshu Shekhar Padhi and Amita Kumari Padhi for a direction to quash the order dated 9/4/2024 passed by the learned DRAT Kolkata in Misapil number 9 of 2024, which was arising out of IN number 1656 of 2023 in SA number 129 of the 2023 of DRT Cutter. In the improved order, the Learned DRAT holding that the interim protection which was granted by the Learned DRT Cutter in IN number 1656 of 2023 arising out of SA number so and so was not in accordance with law, set aside the same and allow the appeal and remanded back the matter to Learned DRT for deciding the essay on merit within a specific period. And in the operative portion, it was directed that the Learned DRT Cutter is to decide the essay number 129 of 2023 along with IN number 1656 of 2023 within a period of 3 months from the passing of that order. Since more than 5 months have passed the date of passing of the order, we made a query to the parties regarding the status of the essay number 129 of 2023. The Learned Council appearing for the, you are appearing for the bank.
Yes,
Submits that the essay is still pending. In view of the submission made by the Learned Council for the bank, and after going through the improved order, we direct the Learned DRT to expedite the hearing of essay number 123 of 2023 along with IN number 1656 of 2023 and dispose of the same within a period of 2 weeks, 2 months from the date of production of the certified copy of this order by the petitioners. Accordingly, the writ petition is dismissed.
Pardon, Milord, but prayer number 2 not to proceed with shall
No,
because
that is already there in that order itself.
the status quo lesson because they have proceeded with almost terminal.
The rest of the prayer you make there. We are just directing to dispose of the matter within 3 months.
Status quo kindly be granted.
That status quo order is already there in your DRAT order.
We are just coming within 2 months.
My lord, my name may be
Item number 22.
Lord, government has acquired land under Lower Indra irrigation project. Since 2018, the matter is pending for redetermination of the acquired land.
Annexure 1 is pending.
Annexure 1 is pending. Since 37, 2008.
What is your good name?
S. Sunandini.
Matter. Yes.
22 and 25 same.
Sure, 22 and 25.
Item 23.
May I please proceed? 23. May I please? In this three person manner, I am challenging the notice of sale notice. Manner. Annexure 1.
Annexure my lord 1, my lord. Page number 9, my lord.
13.4.
Although total loan sanction amount my lord 9,000 something in favor of me my lord. Now my lord total outstanding with interest my lord total my lord 33 lakhs rupees my lord. And I have paid my lord 2 lakh also 2 lakh 50% my lord 50,000 rupees my lord. I have already paid my lord. Now my lord I will pay information my lord. Can you give some time my lord to pay the amount and
So go to the DRT.
my lord?
Go to the DRT. You cannot entertain this notice 13.4. So many decisions are there. You are appearing for the Canada Bank. Mr. Das for the Canada Bank. Disposed of alternative remedies available.
Item 24.
May I please? Chairman, annexure 3 and 4 is pending before the opposite party number 1, my lord.
Repetition 3 and 4.
तीटा को अलग दिखाओ.
All right. One can be twice and 2.
Whether the same authority is to dispose?
Yes, my lord. No, my lord, there is a collector. The land is not still
No, you have moved an application under section 64(1) before the collector.
collector. Then another opposite party number 1 is annexure 4, my lord.
64(1) 64(1) अल्ले से reference करियो.
Yes, my lord.
Reference सही थी ना नहीं? कल से ही
सेटा जाओ
करिए. Annexure 3.
No, my lord.
हाँ. Annexure 3 Annexure 3 is to be disposed of.
Available.
Item 26.
25,
Please, my lord.
25, 26.
Item 26. It becomes infrastructure, my lord. Because auction was failed in this case. But my limited trade, my lord, the direction may be made for OTS system.
Negotiate with the bank.
Yes. Ready to settle.
The auction has failed.
Yesterday it was listed, so due to holiday matter, it was. So we
No.
go for
He is making a submission that the
You
auction.
can give the proposal for OTS. If
Yes.
it was the bank.
The repetition has been filed by so and so petitioner for such and such relief. Mr. Ramchandra Panigai and his associate filed power for the ICICI Bank, which is taken up very long. The Land Council for the petitioner submits that auction which was supposed to be held on
30th July.
30th July has failed. And the petitioner may be permitted to negotiate with the bank for settlement of this loan account. It is up to the petitioner to approach the bank for the relief shortfall, and the bank is to take into account the grievances. We are not expressing any opinion, disposed of. Yes, Nathan.
Item number 28.
What is the prayer?
For crushing of position notice. Nanti.
Passing. Yes.
Item 30.
The earlier read application, as per your lordship's order, by annexure 5 already disposed of, my lord, towards giving benefits towards rehabilitation and resettlement to the petitioner, as well as refund of the amount of money that is deposit or security money. My humble submission, the case like this, as per annexure 1, the both petitioner have been allotted to.
So what is your prayer now?
My prayer to return back my
deposit.
30. My lord, my prayer to rehabilitation and resettlement to the petitioner, along with to refund back salami or deposited security money, 30,000, 70,000 to each, my lord, by annexure 1.
No, you earlier approached this court.
My lord, your lordship already disposed of my writ application by annexure 5. Please make a glance. Page 40. Page 41.
That is the operative party that dispose of the writ petition with an observation that in case the petitioners file a representation before
copy number 1 collected.
Yes. So that is to be decision has to be taken.
My lord.
So what happened then?
My lord, no decision.
You submitted the representation.
My lord.
That is annexure 6.
My lord, annexure, but date may be wrong, my lord, but that is annexure before the collector, my lord.
No, we do not know. This order was passed on 2/11/2020.
My lord.
Right?
My lord.
Annexure 5.
My
but
lord.
This representation is prior to that. So that means you have already submitted a representation, or you submitted any fresh representation after the passing of the order.
I pray, my lord, before lordship, I may be permitted to file fresh representation.
All right. You have not filed. That means all right. That one. Petitioner's prayer is so and so. Earlier he approved this quote in WPC number so and so, that is annexure 5, which was disposed of as per this one. So the Land Council for the petitioner submitted that though prior to the disposal of the petition, he had submitted a representation on 17/10/2020 before the authority, but no order has been passed, and the petitioner may be permitted to file a fresh representation before the concerned authority. And that is opposite party number 1.
1, my lord, collector.
And the same may be disposed of in accordance with law. 2 weeks time given for filing the representation, 3 months for taking the decision, 2 weeks for communicating the order passed on the representation. From the representation along with a copy of the order passed to them.
Yes.
Item number 31.
May I please, your lordship? The petitioner married one Raghunath Mali. Petitioner the wife.
What is your prayer?
Prayer challenging the impugned order of the London Central Administrative Tribunal without even
5/6/2024.
without serving notice, without
issuing notice to the present petitioner, and the input order has been passed. No opportunity was given by the
Annexure 11 was passed.
My lord.
Let us see. Annexure 11 is applicant is Purnima Mali.
Applicant Purnima Mali filed the application.
And there are 4 respondents.
4 respondents.
You are the respondent number 4.
My lord.
Okay.
I have not received any notice from the tribunal.
Just let us see that. What is the relief sought for?
Relief sought for the respondent number 4. And that is Purnima Mali, where 7/33 of 2023, claiming family pension. Family pension.
Okay.
And
just a minute.
My lord.
So both of you are claiming family pension.
My lord.
As wife of the deceased.
How do you say that there is no notice because
I have not received notice. As per instruction of my client, I have not received any notice.
Notice was because the respondents have filed the counter affidavit as it appears. Paragraph number 3.
My lord, advance copy was submitted to the respondent number 2, who appear also in this case, Mr. Patra. He was also counsel before the London Tribunal. On the basis of advance copy, he filed counter.
This is a matter of 2023. You see, OA number 733 of 2023, and the order was reserved on 16/5/2024, and the order was passed on 5/6/24. As appears from Annexure 11. Have you got the order sheet of that court, tribunal, to show that no, you have not received any notice?
The order sheet I have verified, my lord. Notice is already issued, but in fact I have not received notice.
We do not know. That might have been served on you, might have the opposite. The respondent number 4 after receipt of the notice. Suppose you didn't appear before the tribunal and
So, lordship, can you see the certified copy of the?
Let us see that. Issue notice goes to the respondents.
Which mode they issued notice? Whether notice was sufficient, made sufficient or not?
The councils are present. Both sides are present.
4 weeks time.
4 weeks time.
About to file.
4 weeks time. Sides minutes are going. See how she.
Again, 4 weeks time to filing counterpart and pass them to please.
Right, we are calling for a report from the register of the Central Administrative, whether the notice has been issued to you and whether it has been made sufficient or not. We'll verify the file.
Because of
ଗୋଟେ ସପ୍ତାହ ଭିତରେ ଆସିବ କଣ ରେକର୍ଡଟା ଭେରିଫାଇ ଟିମ୍ ଦେବେ କଣ ଆପଣ ଦେଖନ୍ତୁ
the mode of serving of the notice.
Just petitioner Srimati Sumitra Devi has filed this petition challenging the judgment and order dated 5/6/2024 passed by the Central Administrative Tribunal from a Cuttack bench in OA number 733 of 2023. The Land Council for the petitioner submits that one Purnima Mali filed the original application claiming for the pensionary benefit, retirement benefits of late Raghunath Mali, who was working as senior accountant and retired on 31/1/2018 on attaining the age of superannuation.
And died on 23
died on
23/22.
The petitioner was arrayed as respondent number 4 in the original application. The sole ground that has been taken in the writ petition in challenging the impugned order is that no notice has been issued, has been served on the petitioner, even though she was the respondent number 4 in the original application. In support of such stand, the land counsel for the petitioner has produced the order sheet of the original application, which indicates that after admission, notice was issued to the respondent to file counter. What is the first order date? एवढा सब ये Whitener बताइए.
The registry has made this.
And the date was fixed to 5/1/2020. And thereafter the case was adjourned from time to time, and on each occasion, on each date, it has been mentioned that both sides are present. However, from the order sheet, it is not clear that whether the notice on the petitioner, who was the respondent number 4, has been made sufficient or not. Let a report be called for from the registrar, Central Administrative Tribunal, Cuttack Branch, in OA number 733 of 2023, bracket linked to dispose of on 5/6/2024, as to whether the notice on the petitioner hyphen respondent number 4 has been made sufficient or not. If so, on what date? And whether any learning counsel appeared for the respondent number 4. The report be furnished to this court within a week. The registered judicial shall communicate the order passed today to the land registered CAT Cuttack Bench. Put up this matter in the week commencing from 23rd of September 2024 with the report of the land register.
Same case admission heading so that
I promise. The land and council, please give the name so that it can be. Just a minute. Your name is not there in the.
not there.
Acha. Mr. Padhikar na likha ho.
No, it is separate channel. The accountant is not separate.
Acha. You are supposed to file the appearance memo or
appearance.
Acha, you have filed appearance.
Yes, I have. No, I have not.
Then, Acha, please give the names in the slips. You want to submit that he intends to appear in this case and file the appearance memo. The names of the land and council be mentioned in the cause list for opposite party number 1, 2, 3. So also submits for opposite party number 1, 2, 3 that he will file the appearance memo within a week. The names of these land and so on should be mentioned in the cause list and submitted. But Mr. Jitendra Kumar Lenka with the land council for the petition also. So Mr. Lenka, it will come on 23rd of September 2020.
Yes,
Item 32.
Item 32, I have a limited grievance before this honorable court. My lord, my land was acquired for extension of NH 255. For enhancement of my compensation award, my lord, I made a representation. Since there was inaction on the part of the collector and the competent authority, I approached the state government under 5T, my lord. Lordship may see page 28, annexure 4, my lord.
You see that if proceeding under 3G5 of the NS Act is to be initiated,
My lord,
that is your prayer.
my lord.
देखिए सीरियल NH Act 3.
Lordship permits, I will place on 3G5.
Yes. PG relates to determination of the amount
My lord.
payable as compensation. And 3G5 says if the amount determined by the competent authority
is not acceptable by either
subsection 1 or subsection 2 is not acceptable to either of the parties, the amounts are on an application by either of the parties be determined by the arbitrator to be appointed by the central government. So
my application has already been forwarded to the collector for arbitration, my lord. Lordship may see page annexure 4 page 28.
No, annexure 428 is what about that?
No, Lordship may see last para. ଆପଣଙ୍କ ଦୃଷ୍ଟି ଆକର୍ଷଣ
No,
କରିପାରିବି
that is a representation you made before 5T where it is said that the Tahsildar will see it. ଜଗତସିଂହପୁରଙ୍କ କାର୍ଯ୍ୟାଳୟ ପତ୍ର ସଂଖ୍ୟା ଏତିକିରେ ଆର୍ବିଟ୍ରେଟର କମ୍ କଲେକ୍ଟର ଜଗତସିଂହପୁରଙ୍କ ନିକଟକୁ ବିହିତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ନିମନ୍ତେ ପ୍ରେରଣ କରାଯାଉଅଛି. So they have referred it to the arbitrator.
Till then, my lord, no action has been taken or any case.
Annexure 5, 4. But why don't you move directly to the arbitrator?
My lord, here I have already moved before the
Where is that?
arbitrator. Annexure 3, my lord.
Annexure 3.
3, my lord.
So that is pending.
That is pending.
ଷୋହଳ ନାଇଁ ଏଇ ଯୋଉ ଚିଠିଟା ହଉଛି 16/8 ର ଯୋଉଟା annexure 4 ଟା annexure 4 ରେ ଆପଣଙ୍କ ଦୃଷ୍ଟି ଆପଣ ସମସ୍ୟା ବର୍ତ୍ତମାନ ବଜାର ଦର ହିସାବରେ ଅନୁକମ୍ପା ରାଶି ପ୍ରଦାନ ସମ୍ବନ୍ଧରେ ବିଚାର କରାଯାଇ ଏହି ନିଷ୍ପତ୍ତି ନିଆଗଲା ଯେ ଆପଣଙ୍କର ଅଭିଯୋଗ ପତ୍ରକୁ ତହସିଲଦାର ଜଗତସିଂହପୁରଙ୍କ କାର୍ଯ୍ୟାଳୟ ପତ୍ର ସଂଖ୍ୟା ତାରିଖରେ ଆର୍ବିଟ୍ରେଟର କମ୍ କଲେକ୍ଟର ଜଗତସିଂହପୁରଙ୍କ ନିକଟକୁ ବିହିତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ନେଇ ପଠାଯାଇଛି. So that means it is sub judice before the collector Jagasingh.
But they have not yet initiated.
That is what annexure 3 is pending.
Achha.
Annexure 3 that is to be disposed of.
This expedition has been filed. For inaction of the opposite party number 1. Collector from District Magistrate Jagasingh.
Right.
For initiating arbitration under section PG5 of the NS Act 1955 on the grievance of the petitioner for enhancement of compensation. The learned counsel for the petitioner drew the attention of this court to annexure 4, which is the later dated 16/8/2024 of the sub-collector Jagatsinghpur bracket grievance cell. From opposite party number 3, wherein it is mentioned that by the official letter dated number 2851 dated 15/7/2023, the matter has been referred to the opposite party number 1 for necessary action. The Land Council submits that the petitioner has submitted a representation by annexure 3 before opposite party number 1 for initiation of the arbitration proceeding. But no response has been received from the collector regarding initiation of such proceeding, and the application is pending as such, and therefore necessary direction being issued to the opposite party number 2 through the net court for initiation of the arbitration proceeding. Section 3G of National Highways Act 1956 reads as follows: quote that since the matter has been referred for the arbitration to the opposite party number 1 on 15/7/2023 by letter dated so and so, and the application of the petitioner is also pending in that respect, that the collector take necessary decision in initiating the arbitration proceeding under section so and so within a period of 4 weeks from the date of production of the certified copy of the order, and then after hearing the parties, take a decision in that arbitration proceedings within after the appearance of the parties within a 3 months thereafter, after the appearance of the party. The orders are be communicated to the petitioner within a period of 2 weeks from the taking of the decision. Yes, disposed of.
Item 34.
Annexure 4 is to be disposed of.
My lord, may I pray, my lord, one matter, similar matter, item number 59 was on Thursday. Item number 59, WPC number 20968/24. Similar order may be kindly passed.
59 ଅଛି କି କପି ଅଛି?
କପି ଅଛି ପାଇବି ଆଜି।
ଅପଲୋଡ ହେଇଥିବ ଆପଣ
ଦେଖିନି। ଆଇଟମ ନମ୍ବର 59
ସେଇଦିନ ସନ୍ଧ୍ୟାବେଳେ ଅପଲୋଡ ହଉଛି ଦେଖିଦେବେ ହେଲା। ଆଇଟମ ନମ୍ବର 15 କେତେ ନମ୍ବର?
ଆଇଟମ ନମ୍ବର 59 WPC ନମ୍ବର 20968/24.
968/24 ପିଲା ଲାଷ୍ଟ order annexure 4 is to dispose of. Yes, next.
Item 36. Item 37.
Made PGRs. Your Lordships challenges the inaction of the opposite parties. They have acquired the land is out of the petition's 18 decimals land to construct the aluminium park, approach road to the aluminium park from the National Highway Lordships, which has been constructed and but without purchasing the land from these petitions and without giving compensation, Lordships. So in this regard, Lordships, I have also land acquisition before the land acquisition option. Annexure 5 is pending, Lordships. Date that is 2023 Lordships. 21/2023 Lordships.
January 2023.
This miscase has not yet been registered even. Your Lordships, they are as per instruction, Lordships, they have not registered the number. Okay. In fact, they are telling, in fact, one of the legal heir is not cooperating, your lordships. But we are agree, other professionals are ready to. No, you want the matter to be disposed of by the special land acquisition. You should take a decision. This petition has been filed for so relief submitted that LMS case has been filed before the special land acquisition officer Nalco on board on 20. 2023. Again. 2023. But he said case has not yet been registered and no steps have been taken by the special land acquisition officer. It's a number of OP1. And direction may be issued to the opposite party number 1 to expedite the proceeding. Considering the submission made by the uncounseled so if the LMS case is still sub judice to so the opposite party number so do the needful to issue notice to the parties, and after hearing the parties, after appearance of the parties, dispose of the same in a period of 3 months from the date of appearance of this party. Expressing no opinion on the merits of the case, and the order is to be communicated to the. It's a personal hearing, maybe opportunity of personal hearing. Personal hearing is to be.
I mean, pardon to mention, my lord, criminal appeal number 111118 of 2023. The appellants are in custody since 2013. It will come next week.
Pardon, your lordship. In criminal appeal 117 of 13, your lordship. The custody since more than 15 years.
Weekly list, item number 6.
Yes, petitioner has filed an application to interim bail. He has never misutilized. Earlier, he was released by your lordship, and he has never misutilized the liberty.
No, interim bail on what ground?
Is needle ongoing treatment.
Second.
Leukemia, blood cancer.
Right.
Custody since 2010.
Good. Carol. Russell.
Miller, he is in custody since 7/10/2005. More than
That's it. You are filing this interim application on a particular for a particular reason. It is.
He was the only earning member of the family. That's not true.
You see, the report is that the father of the niece is one Pradeep Dalai. And he is alive staying at Mansingh Patna in his own house with his family members. Applicant has 4 brothers. Out of them, one is dead. His name is Pratap Dalai. And all brothers are staying separately with their family members. So
they're engaged in business and private service.
Father of that Ankita is having grocery and vegetable shop at Mansingh Patna. Why you will be granted bail for your niece? His father is there.
Yes, ma'am.
He is looking after the health of the so and so.
The huge amount is required. He can arrange.
He is having a business there.
A business, small businessman, only for survival.
Grocery,
All
vegetable.
grocery shop. This case is of year 2010 and ready for hearing. Let it call on hearing.
Even the matter has been heard for on several occasions.
No, on this ground we are not inclined.
It is up to you.
On the other ground, that's IN number 1743 of 2024. There is an application for bail on the ground that the niche of the petitioner is having health problem. Medical documents have been annexed to the interim application. We asked the Learning Council for the state to obtain instruction. Today, Mr. Tripathi has produced the written instruction received from the inspector in charge of Lalbagh Police Station, Cuttack, UPD, dated 9/9/2024, wherein it is indicated that the father of the niece of the petitioner is alive in a separate house with his family members, and he is running grocery and vegetable shop at Mansingh Patna. And of course, it is stated that the niece of the petitioner is suffering from so-and-so hepatitis and is under treatment so-and-so. In view of the report furnished by this so-and-so, we are not inclined to grant interim bail to the petitioner, which is according to dismissed.
Because I am for the informant.
Mr. So-and-so is appealing for the informant. How can how can
I am for the informant.
Yeah,
Correct, Mr.
Still I am supporting the government in this case.
Learn counsel for no, we did not know for the first time we are hearing it. All right. So she have prepared both din be royale pade asundu. This is just a minute. This is in the first CRL. So what about the other one? That is Raja alias Rajesh Bena.
Yes. So 3 would interim findings.
Nobody is appearing.
Yes, please.
8 of urgent for the CRLA 243 के जो आई है non appears to urgent. Yes.
Obligation.
ଆଷ୍ଟରେ ଆସିକିନି ଆପଣ ନାଇଁ ନାଇଁ ଆମେ ଡିସମିସ୍ ତ କରୁନୁ କିଛି ଜଷ୍ଟ ଯଦି କିଏ କାଉନସିଲ ନଥିଲା ଆମେ ଏବଂ ଶେଷରେ ପୁଣି ଆଉଥରେ ସବୁତକ ପୁଣି ଡକା ହବ ତେଣୁ କୌଣସି ମ୍ୟାଟର ଇଏ ନଥିଲେ ଆଡଜର୍ନମେଣ୍ଟ ଫାଇନାଲି 2-3 ଥର ଡକା ହବ ନଥିଲେ ଆଡଜର୍ନମେଣ୍ଟ ହଁ
Item number 7. Item 8.
Commission of delay in 2015 criminal appeal. No, stamp reporting देखेছি delay within delay
only.
Oh, future control.
Select for the selling.
Oh, ये फाइल को दे चुपचाप रहिएगा. I didn't think that.
No, I guess.
So, Mr. Tripathi.
Yes, ma'am.
It's a criminal appeal of the year 2015.
Yes.
And it's a life imprisonment case. But no step has been taken by the running counsel for the appellant. So you obtain instruction whether he wants to engage any other counsel, and if not, we can engage a counsel from the legal aid, or the High Court legal aid. So, and we are also seeking through this the London trial court also the obtain instruction. You also obtain instruction. Click on the IA number so and so. There is an application for condonation of delay. Non-appears. This criminal appeal is of the year 2015, and the petitioner has been sentenced to life imprisonment under section 302 of the Indian Penal Code. The matter was listed for the first time today as defect pointed out by the stamp reporter was not removed. Let the Land Council for the state obtain instruction from the appellant petitioner as to whether he intends to engage any other counsel for prosecuting this criminal appeal, and it is to be informed to the appellant that if he has got no financial capacity to engage a counsel, then a counsel from the High Court Legal Services Authority will be provided to him. The Register Judicial shall also make necessary communication to the London Trial Court to obtain instruction in that respect from the appellant. ଯେତେବେଳେ ଭିନାମା ଫାଇଲ କରିଥିଲେ ସେତେବେଳେ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ ଫୁଲବାଣୀରେ ଥିଲେ, ବର୍ତ୍ତମାନ କୋଉଠି ଥିବେ we do not know, ତେଣୁ ଆପଣ instruction ନିଅନ୍ତୁ. List this matter in the week commencing from 23rd percent.
Item 9.
My lord,
Just wait. No, first place because কার্ড হচ্ছে মানে এফআইআর হচ্ছে ফিরিঙ্গি অ্যাপিয়ার্স কেস নম্বর 2013 কনভিকশন হলো 2014. Alright, next question.
Item 9.
Item 9, my lord, pursuant to your lordship's order, appellant number 3 has already been surrendered, my lord, after availing bail, interim bail. Surrender certificate I am filing here with me.
Who is this Devraj Behra?
My lord, appellant number 3.
Right. He was released on interim bail by order dated.
Dated, my lord, Tiris now, my 30
ना नहीं 30 किंतु 11/8/18 appear করছি
He was granted interim bail for a period of 1 month.
1 month, my lord.
Right.
Yes.
That was the order
31/7.
Order number 64 dated 31/7/2020. Correct. The learned counsel for the petitioner. Learned counsel for the appellant number 3 has filed the surrender certificate of the appellant number 3.
Devraj alias Litu.
Devraj Behra alias Litu. The memo which is taken on record. The learned counsel for the state has also produced written instruction received from IIC Lalbagh Police Station dated 10/9/2022, wherein it is indicated that during the period of interim bail, the appellant number 3 was appearing before the IIC Lalbagh Police Station on every Sunday. And during this period, he has not involved in any criminal activities, nor any complaint had been made against him by anybody. The report is taken into account. Yeah. Yes.
Item 10.
Please, your lordship, let's hear your lordship was pleased to grant me interim bail for a period of 1 month. The interim bail by order dated 29/7/2024. The interim bail period is due to expire this Friday. Therefore, I am praying, my lords, lordship may adjourn the matter to next week so that I can file the surrender certificate and your lordship can hear my prayer for bail.
The learned counsel for the petitioner submits that the surrender date of the appellant is fixed next week, and the matter may be taken up a week after for filing the surrender certificate. Please, this matter in the week commencing from 30th September 2024 for filing the surrender certificate of the appellant. Yes.
Item 11.
My lord, on behalf of Mr. Surya Kumar Trivedi, this matter kindly taken on 2 weeks after.
Okay, after 2 weeks taken.
Item 12.
Wait, please, your lordship. My surrender certificate is at flag H, your lordship. This honorable court by order dated 13/5/2024, order number 9, in IR number 600/2020, has been pleased to grant me interim bail period of 3 months. And your lordship, I have surrendered in time. That after your lordship's order, I was released on bail on 27/5/2024.
Right. This is the surrender certificate filed by the learned counsel for the appellant number 1. Yes.
My lord, I have filed an IA, your lordship. My lord has called for a report. Since this bail application was disposed of, I have filed IA 2132/2024. I am in custody since last 10 years. Your lordship has been pleased to call for a report from the government learned counsel for the state to
No, there is no such order.
My lord, I am reading your lordship. That is,
Which is the order dated?
order dated your lordship 13/5/2024, order number 9.
13/5 you are granted interim bail.
Again, last page of the order I am reading. Last page of the order for the above period. Let the appellant number 1, petition Santosh Kumar Panda, be released on interim bail.
All right, you obtain now instruction. The IA number so and so. This is an application for bail of appellant number 1. Since the petitioner, after availing the interim bail period of 3 months as per order dated 13/5/2024, passed in IA number 600 of 2020, has surrendered, did the Land Council for the state obtain instruction as to whether there is any allegation of misutilization of liberty by the petitioner while on interim bail. It will be obtained from the IAC of Mahila Police Station, Raut Chalana. Yes.
May I pray, my lord, lords may call it in a short, because there is no male member. Father is dead.
Just recently been.
Madam.
Yes, next.
Obliged, lords.
Item 13.
ଜଣେ କିଏ ଏକ୍ସପାୟାର୍ଡ କରିଗଲା ଆପେଲାଣ୍ଟ ନମ୍ବର 8 ବୋଲି ଆପଣଙ୍କୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଇଟମ ନମ୍ବର 13.
He was reading at Jharkhand.
Sujan Naik.
Yes, the SP has communicated to their counterpart, but no instruction received so far.
ଏଇଥିପାଇଁ କେତେ ଦିନ ଆଉ ଆପଣଙ୍କର ଏଇ ଯୋଉ ଏ ସବମିଶନ ଟା ସେ ଫାର୍ଷ୍ଟ ଟାଇମ କଲେ ବୋଧେ 23/7/2024 ରେ नो ତା ପୂର୍ବରୁ କରିଛନ୍ତି 15/7/2024 ରେ we have mentioned that it is stated at the bar that appellant number so and so are date ତେଣୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଥିଲା ଆଣିବା ପାଇଁ ଆପଣଙ୍କୁ ପାଖାପାଖି 2 ମାସ ହେଇଗଲାଣି ଆପଣ
29/7 ଗୋଟେ ଚିଠି ପଠେଇଛୁ 5/8 ଆଉ ଗୋଟେ
କୁହନ୍ତୁ ପର୍ସୁ କରିବେ ଏତିକି ଜିନିଷ ସେ କଣ ଏସପି କଣ ନିଜେ ଯାଉଛନ୍ତି ନା କଣ ସେ ଆଇଆଇସି କି ପଠେଇବେ ଯଦି ଇଏ ପଠେଇବେ ସେଠିକାର ବି ଯୋଉ ଏସପି ଆଇଆଇସି କହିବ ଘରକୁ ଯାଇ ବୁଝିକିନି ଆସିକିନି ଦେଖିକିନି ଏନକ୍ୱାରି କରି ରିପୋର୍ଟ ଟା ଦବ ଆଉ କଣ Land Council for the state submitted that instruction has already been sought for by the Superintendent of Police. Sundargarh to the Superintendent of Police. Jharkhand, na? No, Jharkhand to state, 4 district. Superintendent of
Simdega
in the state of Jharkhand for obtaining instruction regarding the death of the appellant number 8, Sujan Naik. But the instruction is still awaited and the matter may be taken up after a week. Out of this matter in the week commencing from 30th of September 2024. Instruction be obtained in the meantime.
Item 14.
My lord, in the last occasion, your lordship was pleased to allow time to the learned counsel for the state to produce the custody certificate of the appellant number 2, also obtain instruction regarding the criminal antecedents if any under the appellant number 2.
Appellant number 2 किए ना कौन?
पीताम्बर बेहरा alias दासुडू.
ये 302 केसটা এই কেসটা
Miller.
কেন होगा না আউট কেস আউট কেস let us see the judgment. এটা হচ্ছে কেন होगा PS কেস নাম্বার 42 হ্যাঁ সেইটা মিস্টার ত্রিপাঠী এই কেসটা যেটার এটা ক্রিমিনাল অ্যান্টিসিডেন্ট নয় এটা এই কেস বিষয়ে দেখি আর কস্টোডি সার্টিফিকেট করতে আসলে
9 years, 3 months, 9 days.
Under trial वाला 1281 दिन conviction की total of so till 9 years 3 months 9 days अच्छा phase 2 days तो आगुर reject ही ना first time
Miller, three occupancy has been released on interim bail.
interim bail
Miller. English matter never rejected. The appellant number 1 is dead. Other of the present appellant number 2.
no
Problem jail custody.
now post I this interim application for bail of appellant number 2 only okay. So that is IN number 105 of 20
Miller, this is the present application is for regular bail. Earlier has been released on 3 occasions.
Your number is IN number 105 of 2020 or 105 of 20
105 of it is lying since
2020 so let us see the
ground is different.
और तापर जो interim bail होगा सिर्फ फाइल को नहीं चेंज होगा ऑन द ग्राउंड मेरिट रे सो कितने बड़े बापा एक्सपर्ट करते भी जाएगी
Government press
मैरिज नो आंसर IN number 20 you do one thing, you file a fresh application. This is a 2020 because thereafter you have been released on bail on in different IA. So this old application was pending. Now, if you say you take this ground that you are in custody as appears more than 9 years, whatever it may be, so file a fresh one letter. IA number so and so 30105 of 2020. Grant counsel for the petitioner seeks permission to withdraw this application to file a better one. Accordingly, IA is disposed of. Yes. Yes, yes, of course.
This application for bail.
This application for bail.
Item 15.
You have filed the custody certificate which you have taken on the class. Yeah.
Item 15.
In this case, the present appellant petitioner pleading for bail matter. Earlier, the bail application was dismissed matter on 26/11/2018. Petitioner is since arrested on 23/3/2015. And
actually, the argument for open up that IA.
This matter.
IA number 1953 of 2020.
IA number 1953 of 24.
Since when you are in custody?
My lord, I am in custody since 23/3/2015. Since the date of the arrest, my
You
lord.
have never been released on bail in the meantime.
No, released on bail, my lord, but on IA, on the ground of the wife health, he has been released for 6 weeks, thereafter extended for 8 weeks. That I have stated in my petition, my lord.
It's all right, but during that COVID period,
Yes, COVID period he has been also some period that is.
so actually, what is the period of your detention? Have you got any custody certificate with you?
My lord, 1 minute.
So it is not that 2015 you are all along in custody.
Yes, yes.
It's not that you are in custody for 9 years.
My lord.
Because you have been, as you said, you have been released on interim bail. During COVID period, you have also been.
My lord.
So that is to be excluded. We want to know that actually what is your custody period.
My lord.
So you have not got that surrender your custody certificate with you.
My lord.
Jail superintendent को nahi ko. All right. The IA number 1953 of 2024. This is an application for bail. Let the Land and Council for the state produce the custody certificate of the petitioner. Put up this matter in the as well as the take instruction about the criminal antecedent claim against the petitioner.
Udala.
Wakalatnama was filed from Circle Jail, Baripada. I think you asked you. Next.
Confirm code.
Item 16.
Please, there you go.
Yes, please, your lordship. My lord, appellant is convicted from 302 of IPC, my lord. Is in custody, my lord. Custody certificate file, my lord.
1593.
My lord, 1593 of 24, my lord.
So what order was passed last time?
Last time the position copy, I'm sure.
Right. 2924. 2924 order was.
Custody certificate, my lord, filed, man.
That is filed.
Yeah. As a custody certificate, my lord, kindly take a glance, my lord. 20/4/24, I am in custody 11 years, 9 months, and 17 days. Now,
your bail application was never rejected.
Rejected, my lord.
Okay. So more than 11 years you are in custody.
12 years, my lord.
12 years. Okay. Now let us come to the for what offense you have been found guilty and what is the sentence?
302, my lord.
302.
My lord.
Okay. And eyewitnesses are there.
No eyewitness, my lord. Circumstantial evidence, my lord. And the wife, her husband is my
Oh, your husband is the deceased in this.
My lord, my lord.
12 injuries.
You are with your husband.
Husband and children. One son, one sister, my lord. The doctor.
Sure. What wound would I achieve? Putre martile, mana. You are having how many children?
Two son, one doctor.
Sons, one daughter. Why? What is the reason behind it, according to the prosecution?
Reason behind this prosecution is PW1, the brother of the deceased my lord. The allegation some stolen property was his house is deceased stolen some property to cash to the my lord,
and there is a village meeting, and the village meeting, the villagers and the Sarpanch was decided to give 10 lakhs towards the cost of stolen articles to the temple of our village by the PW 1 million.
अच्छा
No unity between decision husband and wife.
The deceased was found lying dead
Inside the room,
in the bedroom, and with the cut injuries on the neck and both the legs, so on, so on. So that is the material. Deceased was as a paragraph 10 Puchi, accused has 2 daughters, 1 son. Son Sunil Sahu is aged about 16 years. Eldest daughter is so and so. 2013 ମାନେ ଅବିକା ପିଲାମାନେ ଆଜ୍ଞା ବହୁତ ବଡ ହେଇଯିବେ 26-27 ବର୍ଷ ହେଇଯିବଣି ବଡ ପୁଅଟା ତାଠୁ ବଡ ଝିଅଟା ବି ଆଉ ତାଠୁ ବଡ ପିଲାମାନେ କିଛି ଏଭିଡେନ୍ସ ଦେଇନା ପିଲାମାନେ କିଛି ଏଭିଡେନ୍ସ ଦେଇନା
ଦେଇଛନ୍ତି କିନ୍ତୁ କହିନାହାନ୍ତି ମାରିବା ଫାରିବା କିଛି ଦେଖିନାହାନ୍ତି
କଣ
PW 14 is the son, 15 and 17. 14 PW 14 million.
No, exemption that is 14.
PW 14.
14 টা doctor.
ଗାୟତ୍ରୀ ଲେଖା ହଉଛି PW 14 ନାହିଁ PW 14 ହଉଛି ଗାୟତ୍ରୀ ସାହୁ item number CRL 457, item number 60.
PW
14
Gayatri Sahu.
Sahu is daughter.
So this
is my father, accused once is my mother. My father died once. Taking either of my mother, brother, once, and daughter, and so my father died reading and news and the like. I heard from my mother that uncle killed my father. And she's asked me, so do I want to push up from to inform the same arrangement? I have no knowledge how my father sustained injuries resulting in his death.
Hmm. 20 years then. She was quite. Yeah.
Are the learning council for the petitioner, learning council for the state. As per the custody certificate produced, key produced with Lapona, produced by the learning council for the petition. It appears କେତେ ବର୍ଷ ଯାଏ ରହିଛି
20/4/24 ରେ ହେଇଛି 11 ବର୍ଷ 9 ମାସ 17 ଦିନ
24 and for his custody for more than 12 years. The land council further submit that the case is based on circumstantial evidence and the prosecution has failed to establish any motive on the part of the petitioner to kill the deceased who was her husband. And there are good chances of success in the case balance of convenience is in her favor. And therefore the bail application may be favorably considered. Land council for the state propose the prayer for bail. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing on this one, And since the petitioner is a lady, we are inclined to release the petitioner. Okay, allow this. There is an application for stay of realization of fine, it should be allowed.
My lord, I may pardon, my lord. Item 8, my lord. Due to some problem, I could not reach. For that, there is a direction to intimate the. I have. My lord, item 8, my lord. I could not reach, my lord. In this item, what I have heard from my learned senior, we require that
2015 matter, the delay is there and you are not.
2 days delay, my lord.
That's not the thing. We do not know that the client has entrusted you to file a regular appeal, and from 2015 you have not even taken any steps for condoning the delay. Just by filing that interim application in you have said just 2015 ରେ ଗୋଟେ criminal appeal file କରି 302 ଜଣଙ୍କୁ life imprisonment ଦେଇଛି। 2 ଦିନ delay ଅଛି, ଆପଣ ଚୁପଚାପ ବସି ଯାଇଛନ୍ତି।
My lord, thereafter one person has engaged me and whatever me I could not. After they are coming to me and I have took the necessary steps.
ନଥିଲେ
ମତେ ଆଗରୁ ଦେଇଥିଲେ।
ଆଉ ତାହେଲେ ଆପଣ criminal appeal file କରିଥିଲେ?
My lord,
ତାହେଲେ
only 2 days delay ଅଛି password।
ସେ ଅର୍ଡରଟା କିଏ ନେଇଛନ୍ତି ତ କାଟିଦେବେ। আর the item number so and so এটা ভাগ করলে item number 8 তো item number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 2 days in filing the criminal appeal. After hearing the land counsel for both the parties, since it's a case where the petitioner has been sentenced to life imprisonment, the time to condone the delay accordingly delay is condoned. IA is disposed of, part admit call for the trial court reform.
ଭିନ୍ନଟା ଜଣେ ଫାଇଲ କରିଛନ୍ତି ମନୋଜ କୁମାର ପତି ମନୋଜ କୁମାର ପତି।
After filing of the after since it's a criminal appeal of the year 2015, the preparation of the paperwork may be expedited. Yeah.
Item 17.
Yes. 17.
Item 18.
May please. Lords, may kindly see the order dated 24/8. Last order.
24/8 or 27/8?
27, sorry, 27/8. By that order, Lordship directed.
No. There are 3 orders have been passed. 3 to.
Yes, yes.
Oh, which order you want to show?
That order, Lordship.
Order number 6 or 7. Order number 7 is the first order. Mr. Dhar has filed so and so. In view of the name of so and so shall not be reflected. Does not want to pay. There is an application for bail.
My lord.
That is IN number 1664 of 2024.
My lord. There, Lordship directed the State Council to obtain the instruction with regard to the custody period of the appellant. In fact, the bail application was earlier rejected by this Honorable Court while admitting the appeal, my lord, by order dated 14 to 20. And while rejecting that bail application, Lordship permitted the appellant to move application for bail after 1 year. That was on 14 to 20.
8 years, 6 months.
8 years. When it was rejected earlier?
14/2/20. Their lordship also granted me liberty to move for bail after 1 year. Last sentence of that order, 14/2/21.
IA number so and so, this is an application for bail. As per the order dated 27/8/2024, the London Council for the state has produced the custody certificate from Superintendents of Jail Barbi, which indicate that the petitioner is in judicial custody for 9 years.
8 years.
8 years.
8 years, 6 months.
8 years, 6 months. The custody certificate is taken on record. Mr. Dhawal and counsel appearing for the petitioner submitted that the petitioner's earlier bail application was rejected as per order dated 14/2/2020. However, liberty was granted to renew the prayer for bail after 1 year. It further submits that since there is no chance of early hearing of the appeal in the near future and paper book has not been prepared, the bail application of the petitioner may be favorably considered. Land counsel for the state opposed the prayer for bail. Since the bail application of the petitioner was rejected on merit earlier, taking into account his period of detention in judicial custody and the ritual let down in the case of elective songs, we are inclined to release the petitioner on interim bail for a period of 3 months. And he has to surrender and IAC report to be submitted regarding his conduct. Yes.
Item 19.
After to be placed after 3 months.
Wait, please, my lord. My lords, I'm appearing virtually, item 19 now.
Yes.
My lords, on the last occasion, an IA had been filed for release on bail of appellant number 2, my lords, and the State Council was directed to seek instructions with regard to his health ground, my lords.
Appellant number
2.
My lords.
Dilip Kumar Naik.
Udayanath Naik.
That is appellant number 3.
That is appellant number 3.
I beg deep apologies.
Appellant number 3 is Udayanath Naik, not 2.
Deep apologies, my lords.
Kindly this matter will be taken up tomorrow, my lord.
Okay. So it will be taken up tomorrow.
My
On 11.
Item 20.
Item 20, my lord. My lord, in this case, life condition and a condition 323, 6 months, 1 month. The accused is a custody, my lord, from 14/6/2012 till then 13 years already complete. The relationship of the accused and deceased father and son.
Wait, just a minute. Where is your custody certificate?
I mean, I do interim bail.
No such order regarding the custody certificate, my lord.
Achha.
I mean, interim bail I do.
It's all right. Let him bring it. IA number 165 of 2024. There is an application for bail. Mr. Sarangi Land Council appearing for the appellant submits that the appellant is in judicial custody for more than 12 years, no?
More than 12, 13 years.
More than 12 years. And stop. Where the Land Council for the state produce the custody certificate. Who jail she?
Another on
Angul jail. Put of this matter in the week commencing from 23rd September 2020. Cody. And custody period of 5 weeks on
ନାଇଁ ଏଇଟା ତାର ନୁହଁ ଏମାନେ ଦେଇଥିଲେ ସାର୍ଟିଫିକେଟ ନୁହଁ ଅଥେଣ୍ଟିକେଟେଡ ନୁହଁ ସେଟା ସେଟା
ଆଇଓ କହିଛି କେବେ ଆସୁଛି
ତାର କିଛି ବିରେ ଗୋଟେ କିଛି ଦିଆହେଇଛି କାହାର କିଏ ଜାଣି
ଏଟା କିଏ ଦେଇଛି ଏଟା ଏଟା କୋଉଠୁ ପ୍ରଡ୍ୟୁସ କଲେ କିଏ ପ୍ରଡ୍ୟୁସ କଲା ଏଟା
ସିଆରଏଲ କ୍ରିମିନାଲ
କିଛି ମାନେ କିଏ ଦେଇଛି ନା ନାହିଁ ସିଲ୍ ନାହିଁ କିଛି
ସୁକଦେବ ବେହେରା
No, no, indicating.
Item 21.
That legalers. The Maiva present appellant convicted in section 302 IPC for life murder and petition inside custody number 8/11/2013.
case. Agu reject ହେଇଥିଲା
Here I am appearing after obtaining.
Just a minute, let us see that order. No, rejecting. Have you got the custody certificate, Mr.?
No, madam.
IA number 306 of 2020. This is an application for bail. When counsel for the appellant submits that the appellant is in judicial custody for more than
8/11/2013, more than 10 years.
Than 10 years. Let the land counsel for the state produce the custody certificate. Put of this matter on 23rd of September 20.
Conduct.
Item 22.
No, please, my lord. Transfer Perus order dated 27/8/2024, my lord.
Instruction and he was released on interim bail for 3 months.
Yes, my lord. That is 19th.
You are to obtain instruction whether there is any allegation of misutilization of liberty while on interim bail.
So tomorrow, madam.
Tomorrow.
Madam.
Item 23.
Please, my lords. Lordships on the last occasion was pleased to call the criminal antecedent, if any, against the present appellant, my lords. The appellant is behind bars since 15/2/2015, my lords. Was fixing his
last order is 27/8/2024. There nothing was stated. It's just adjournment was sought for Lakai.
The order prior to that, words.
Again. Deposition copy the state council wants to take instruction about the criminal antecedent. That is the order dated 37/2024.
Madam, though the instruction was received, the father name is wrongly mentioned, so that it was also taken up on tomorrow, my lord. I confirm.
Other name?
Wrongly mentioned as Vanshidhara Swai. First title address was Vaikunta Swai.
She's a lekhi
For the CA, my lord, the IIC sent the same as son of Vanshidhara Swai. That's why tomorrow, my lord.
Okay, tomorrow is so.
Item 24.
The last occasion order dated 31/7/2024, my lord. My lord had called for the custody certificate and CA of accused, my lord.
Right.
ସେ ଅଫେନ୍ସ my lord,
ଟିକେ ରୁହ।
my lord.
Nine years both wants to Let's see. I will reject that.
My lord, no, my lord.
So
The
you have
offense,
been found guilty under
my lord, 202 of IPC or RI for life, my lord. There is a entire case is based on my lord circumstantial evidence, paragraph 10 of input judgment, my lord.
Page
my lord, input judgment 6 and my appeal number is 22, my lord. Paragraph 10, my lord. It is found that
Let's not like it. Case of what are the circumstances?
circumstantial, my lord, extrajudicial confession before PW1 and recovery of weapon, my lord, spade and stone near the dead body and
Just a minute. Extrajudicial confession before
PW1, my lord,
and recovery of
weapon, my lord.
how come?
A body of deceased found on the house of veranda of the accused. From the PW1 and PW3, my lord, PW3 is hostile, my lord. And PW1 is not direct witness, my lord.
So PW1 ର evidence to ଦେଖିବା ଟିକେ। He is a witness to the extrajudicial confession.
My lord.
He is also the informant.
My lord, informant.
Accused is my father-in-law. And deceased is my mother-in-law. Acha, you killed your wife, that is the allegation. Occurrence took place 1 year back and so and so at about 9 a.m. I came to know that there was hue and cry inside the house of my father-in-law, which is about so and so. And found my mother-in-law was lying dead in her house. I informed the matter to the police. And by that time, my father-in-law was not present in the house. Father-in-law stays in his house with his wife. All the children were staying outside. Police recovered. Spade was lying aside. Said what? I inquired about my father-in-law who was missing at that time, and after some time, he was snapped by the villagers. And before me, when he confessed before me that he killed his wife and son, spade, stones he came.
All the injuries are on head.
Stone, doctor here?
Doctor, my lord. PM Doctor, my lord, PW10, my lord. Dr. Wilson Cross submitted that weapon of offense was not produced before me for my examination and opinion.
No, PW1 ର evidence ରୁ ଜଣା ପଡୁଛି ଯେ ଡେଡ୍ ବଡି ଯୋଉଠି ପଡିଥିଲା ସେଠି ଗୋଟେ ସ୍ପେଡ୍ ଆଉ ଷ୍ଟୋନ୍ ଥିଲା। ତେଣୁ ଆପଣ ଯୋଉ କହିଲେ ରିକଭରି ଅଫ ୱେପନ୍ ଆଟ୍ ଦି ଇନଷ୍ଟାନ୍ସ ଅଫ ଦି ଆପେଲାଣ୍ଟ ହେଇଛି ବୋଲି ସେଟା କୋଉଠି ପାଇଲେ ଆପଣ?
ସେଟା ଥିଲା ବୋଲି ସେ କହୁଛନ୍ତି।
ଆପଣ ଆପଣଙ୍କୁ ସବମିଶନ ଯେତେବେଳେ କଲେ you said that what are the circumstances? You said extrajudicial confession. You said second that there is recovery of weapon at the instance
That
of
has been, my lord, in
but we found that the weapons were
my lord,
lying by the side of the body,
my
that is a spade and stone.
my lord,
And by that time, the appellant was also not there.
my lord,
Subsequently, he was nabbed and then he made the confession.
my lord.
So, where is the material that at your instance, the weapon of offenses were recovered?
As because that is present in 35 page of improved judgment, that is why
35 page from the judgment of
judgment.
let us see that 35. Recovery of weapons so and so marked as respectively at the spot. Recovery of weapon মানে at your instance ହେଇଥିଲା ସେଟା ଆପଣଙ୍କ against ଯାଇଥିଲା
Not my instance, my lord.
ଆଉ ଗୋଟେ କଣ କହିଲେ ଅନ୍ୟ କଣ
Another is body of the deceased veranda.
body of the disturbed
Was lying on the veranda.
Lying on the
So they are quite old people. Why child? You are the you are aged about 71 years when the judgment was pronounced by the London Trial Court, and now you must be 75.
7.
Any motive has been ascribed to her?
Motive not true. Motive not true.
ଶ୍ୱଶୁର 71. 75.
Featured witness also, my lord, they are silent also. 9 and 16.
ଯେତିକି ବୟସ ହେଲାଣି
The petitioner land counsel for the state. The land counsel for the petitioner submit that the petitioner is aged about 75 years and he is in judicial prosecution with this case for more than 9 years, and the case is based on circumstantial evidence, and the main circumstance is the extrajudicial confession made by the petitioner before PW1, the informant in this case, and there are good chances of success in the appeal, and the balance of convenience is in favor. Therefore, the bail application may be favorably considered. As per order dated 31/7/2024, the London Council for the State has produced the custody certificate of the petitioner, which shows that he is in judicial custody for more than 9 years and 4 months. He has also produced the report from the IAC, Jharpokria police station, which indicates that there is no criminal antecedent against him. Considering the submission, nature of evidence adduced during trial, age of the petitioner, period of detention in judicial custody, absence of any criminal antecedent against him, so also absence of any chance of early hearing of the appeal in the near future. We are inclined to release the petitioner on bail allowed.
Item 25.
My lords, I am praying one passover, my lord. On behalf of Mr. Lalichandu Misra. He's in his legs in another courtroom.
Item 26.
Oh, next.
My please, lords. Item 26, my lord. Custody with the appeal bail, my lord. Custody since, my lord, 24/3/2016, my lord. An entire case, my lord, based on the circumstantial evidence, my lord. That has been also.
The council was asked to obtain instruction relating to your criminal antecedent.
have obtained only the custody certificate, my lord, regarding criminal assistance.
Certificate ସେଟା ଆପଣ ଦେଇଥିଲେ ନାଇଁ ଆପଣ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମଧ୍ୟ କୁହାଇଥିଲା ଆଣିବା ପାଇଁ
Criminal antecedent.
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଅଛି ଆପଣଙ୍କ ପାଖରେ
One.
ହଁ ନାଇଁ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଆଣିନାହାନ୍ତି କୋଉ ଥାନା ହିରିଂ ପୋଲିସ ଷ୍ଟେସନ
Hearing police.
so get it next week we'll take up the matter all right the land and council for the state submit that those he has received the custody certificate but she is yet to get the instruction regarding criminal antecedent if any against the petitioner and the matter may be taken up next week. Please this matter in the week commence from 17th of September 2024.
Item 27.
May I please? Where the appellant lordship is convicted under section 302-201 34 IPC with section 25 and 27 of the Arms Act.
27, no?
The FR was lodged on
201. Yes.
The FR was lodged on 26th of November 2010 and the petitioner was arrested on 15/12/2010. Thereafter, he was remained in custody and was, by virtue of the order passed by the Honorable Court, he was released on bail on 23/9/2020. Thereafter, the judgment was passed on 15/11/2023. So totally, he is inside custody during UTP period 9 years 9 months and after conviction 10 months. In total, he is in custody 10 years 7 months.
ଆଣିଲେ କି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କିଛି ଅର୍ଡର ହେଇନଥିଲା କିଛି
No.
ହଉ ନେଇ ଆସନ୍ତୁ IA number 602 of 2024. This is an application for bail. Land Council for the petitioner submits that the petitioner is in judicial custody for more than 10 years. The Land Council for the state seeks some time to produce the custody certificate, so also to take instruction regarding criminal antecedent, if any, against the petitioner of this matter in the week commencing from 23rd September 2024.
The stay in a
Casu segment.
Item 28.
Item 28 may be permitted to appear to the BC, my lord. My lordship, the appellant herein under challenges his conviction and sentence under section 302. Lordship, there is a delay of 6 years approximately. Lordship, the petitioner is a poor tribal. He belongs to one of the most interior belts of Kalahandi Nuapada region, my lord. He is presently lodged in...
କେମିତି appeal file ହେଲାନି ଏମାନଙ୍କୁ ଗୋଟେ regularly monitoring ହୁଏ କାହାର appeal ହେଲା କିଏ ନ କଲା ନ ହେଇଥିଲେ କହିଲେ jail criminal appeal ହୁଏ ଏଟା session judge ନିଜେ ଯାଆନ୍ତି ଦେଖନ୍ତି କେମିତି ରହିଗଲା ଏଇଟା ଗୋଟେ
Lordship, this is interested to me.
2069. What is your IA explaining the delay?
My lordship, the petitioner is a tribal from the interior belts of Nuapada, my lord. So he has actually he is, the petitioner and his wife both were accused in the case for having committed the murder of their daughter, my lord. So during the course of
want to know about the condonation of delay. ଆପଣ ଖାଲି paragraph 4 ରେ ଲେଖିଛନ୍ତି ଯେ not having the financial constraint, family members deserted him, not in touch. Weaker section of the society could not stay so answer.
He has no one in his family to look after the case.
Are you sure any jail criminal appeal has not been filed?
I had checked since 2018. I had checked the name of the petitioner in the website of our Honorable High Court, my lord. I didn't find any mention of any pending jail criminal appeal. I'd also verified with the learned jail superintendent.
Right, IA number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is a delay of 2069 days in filing this criminal appeal. The petitioner has been sentenced to undergo imprisonment for life and to pay fine of rupees 10,000 in default of payment of fine to undergo RI for 1 year under section 302. So also RI for 3 years and to pay fine of rupees 2,000 in default of payment of fine to undergo RI for 2 months under section 201 of the IPC, and the sentences were directed to run concurrently by the learned Session Judge Nuapada in ST case number 89 of 2014. As per practice, the Session Judge Nagar used to make a visit to the jail and verify whether any person who has been convicted and whether he has preferred any appeal against the order of conviction or not. The judgment was pronounced on 10/9/2018. Therefore, a report be called for from the concerned jail superintendent, that is Superintendent of Jail M. Rampur, as to why earlier steps have not been taken. No, whether any jail criminal appeal has been preferred for the appellant challenging the impugned judgment and order of conviction, and if not, why there was inordinate delay in the appellant filed this 2024, the criminal appeal in 2024. The Land Council for the state filed objection to the interim application, if any, put of this matter in the week commencing from 23rd of September 2024. The Land Council for the state shall produce the report of the concerned jail superintendent. 3 copy of the order be handed over to the Land Council for the state. ଏଇଟା ବର୍ତ୍ତମାନ ଯୋଉ ରହିଛି वकालतनामा ସାଇନ୍ ହେଇଛି 2024 ରେ
ଏମ୍ ରାମପୁର ନୂଆପଡା ଏଇଟା
ଏଟା
ହେଲେ ଆଉ ଗୋଟେ ଥିଲା ତାର ଏମ୍ ରାମପୁର କେମିତି ରଖିଲେ
Sita Purpura would have
Fever nischay, हाँ.
Lordship, actually, I had to get the certified copy of the deposition and the certified copy of the judgment, my lord. There also some time was lost in preparing the appeal. my lord. After
No, that's not it. 2018 ପୁରା ଆପଣ 2024 ରେ appeal file କରୁଛନ୍ତି this
actually,
criminal appeal is
23
of the year
had
2024. The
yes, my
conviction
lord.
was of the year 2018.
Yes, my
And it is a regular thing. The session judge used to visit every month to the jail and verify that is the procedure. That if anybody has not preferred any appeal, then usually jail criminal appeals are being preferred. Just a copy of the judgment is sent along with a petition, and we register it as jail criminal appeal. So
My lord, sir.
that's a regular feature. But in this case, that the exact reason why we know we are interested to know that whether any JCRLA has been filed in the meantime or not, because you
My
say
lord.
in his name nothing is come out from that
High Court website, nothing could be found.
right. That is why let us see that. Put up so answer.
My lordship, this is a case purely based on circumstantial evidence, my lord. I only pray this for
Mr. Counsel,
procedure.
unless your delay is condoned, the appeal is not admitted. Where is the question of considering your bail application?
My lordship, I bow down.
Yes.
Milord, I may pray, Milord, kind permission. Item 25 was passed over.
23rd September 2022. Yes, next matter.
Oblige.
Item 29.
Maybe the receipt. Your my lord's array is life, my lord, and fine for 20,000. Lord's please, I have for delay, my lord. There is delay for 8 days, my lord. I have number 2110, my lord.
Yes, sir.
Condemnation of delay in filing 39 days.
39 days the reporting as she. So IA number so and so. This is an application for condonation of delay. The stamp reporter has indicated that there is delay of 39 days in filing this appeal. Since the appellant has been sentenced to life imprisonment for his conviction under section 302 IPC. After hearing the land counsel for both the parties, we are inclined to condone the delay. Accordingly, delay is concerned hard admit, call for the trial court report, interim applications for bail and stay realization of time considered after receipt of the trial court report. Yes.
7 days, 8 months has been control, my lord.
Custody certificate we obtain.
My lord. But I am filing the deposition copy, my lord, court.
We do not want it. You give him. We have with us the. Once we get it, that trial court record, it will be with us. So, if you want to.
You also mentioned I am filing to
State Council. The deposition copy is supplied to the land council for the state.
Oblige.
Pass over time.
Pass over item number 7.
Next.
Item 17. Item 25.
May I please, your lordship, I'm sorry, my lord.
Yes, 25.
My lord. My lord, kind direction was there to, my lord, just prepared a list of dates and submission with regard to, my lord, kind hearing of the bail application of the appellant. And the, my lord, the appellant is, my lord, convicted.
Custody certificate quite land.
Lord,
And also the instruction about criminal antecedent.
Your Lordship, your kind permission. Lord, the appellant is in custody since
Regarding criminal antecedent, matter, no instruction has been issued. Regarding criminal antecedent, matter, no instruction has been issued.
Custody certificate केते देखो जाए 10 years 18 days.
My lord.
So in that very order there was a direction 6/8/24.
My lord.
From which police station it is to come?
Barampur.
For Southern, my lord, tomorrow, my lord, I will obtain.
Tomorrow.
My lord.
Right. It was sorry that.
And I pray a day after the Lordship.
Day after tomorrow. Day after tomorrow ले 12 तारीख में. Correct.
Grateful, my lord. Obliged.
12/9/2020. Ready.
Item 30 made up.
30 is there.
May I please? Discuss the accused persons are charged under section 302 and convicted since 2000.
Mr. Tripathi, no, come. ताकू देखिए आर्गुमेंट पे हो जाए. से खाता पता से अर्थ होंगे एटी पड़े तुम सामना
I have prepared a short note.
तो सेटा देखिवा मामे हम केतोड़ा प्रश्न पचारछु ये कर दियंतु तापरे
हाँ 30.
Conviction is under section
302.
302. Okay. You come to the charge page 44. Charge no, say don't. Charge 44. Let's see how this.
44. Charge 44. Page 40. Page 44. Page 44.
पेपर बुक दिखाओ पेपर बुक खोलो
पेपर बुक बेटा कर ले
Handle from ये तोड़े थी FIR तोड़े
जानी
Please read it out.
First, that you on the about 14/4/2002 at 4 p.m. on public road at village Tanshola, in furtherance of common intention, abused deceased Sadak Malik in filthy language on the public road, which caused anyone to him and others. Secondly,
That is 294/34. Then second charge.
Second, that you on or about the aforesaid date, time, and place, in furtherance of common intention, committed the murder by intentionally causing the death of Sardak Malik, assaulting by means of finger and eggs.
Okay, that is 302 by 34. Then third charge.
That you on or about aforesaid date, time, and place, in furtherance of common intention, voluntarily cause hurt to Bharat Naik. 23.
23 by 34. So you are found guilty only under section 302 or other offenses?
No.
No, 302, 323. Come to the judgment last page, page number 34. ସେଠି କାହିଁକି ବସିଲା?
Judgment with judgment.
Judgment last page को आसନ୍ତୁ.
Last page.
Hearing on the question of sentence, page 34.
Page 34.
Paragraph number 18.
Hearing on the question of sentence.
No, you come to the last two lekha hai, hence both the convicts are said for out here thought present, hence both the convicts are sentenced to undergo.
Hence, both the convicts are sentenced to undergo rigorous imprisonment for life under section 302 IPC and to pay fine rupees 2,000 each to undergo RI for
default. Fine not the parle in default.
To undergo RI for further period of 3 months. Convict Santosh Malik is further sentenced to undergo RI for 6 months under section 323 IPC. Sentence against him to run concurrently.
Okay. Now you come to the FIR. Page 37 and the FIR is actually page 39.
37.
FIR click कर दियो तो 39 पेज को पढ़े सुन.
मान्यवर श्रीयुक्त वेतन थाना भारत ऑफिसर महोदय समीपेश महाशय मु श्रीमती टुसी मलिक बयस 50 वर्ष स्वामी श्री सार्थक मलिक.
टुसी मलिक पीडब्ल्यू केते
1.
ओके पढନ୍ତୁ.
श्री सार्थक मलिक ग्राम धानशाला अद्यता 14/4/2002 तारिख दीपा प्राय समय उपरवली 4 घंटा समय मोर स्वामी घर पाखक श्री प्रताप नायक घर आड़ को जाउथुवा बेले श्री संतोष मलिक एवं तार ससुर श्री हेम नायक
डिसीज्ड वाइफ. ओके हां
डिसीज्ड प्रताप नायक.
प्रताप हां यस. घटना है डेट ऑफ ऑकरेंस
घर को सब जाउथिले ता
14/4/2002
आफ्टरनून
4टा बेलू घटना.
आज्ञा
पढ़ନ୍ତୁ तो मोर स्वामी घर पाखरु श्री प्रताप नायक घर आड़ को जाउथुवा बेले श्री संतोष मलिक एवं तार ससुर श्री हेम नायक 2 जण सारा आसी कहउछथि आपको लाइन दिए.
आज्ञा.
संतोष और हेम.
संतोष एंड हेम बोथ आर appellant.
हां पढ़ନ୍ତୁ.
संतोष मलिक एवं तार ससुर श्री हेम नायक 2 जण सारा आसी रास्ता ऊपर संतोष मलिक गोटे ठेंगा धरी बुलुतुला एवं असभ्य भाषा रे अश्लील एवं इत्यादि असभ्य भाषा रे कहउतुला. मोर स्वामी सार्थक मलिक एभली व्यवहार को प्रतिवाद करिबारु संतोष मलिक मोर स्वामी को ब्रैकेटेड बणा मोर स्वामी को ठेंगारे मुंडरे एवं देहरे पिटी तଳରେ पकाई देला. एहा परे बणा सहित थिबा तार ससुर हेम नायक धरिथिबा कुराड़ी रे संगे संगे सार्थक मलिकर मुंडरे हाणी देला. एहा परे सार्थक मलिक मरिगला. परे ससुर एवं ज्वाई घटनास्थल रु दौड़ी पळाई गले. एही घटना समय सेठारे घटनास्थल रे उपस्थित थिबा श्री भरत नायक तांको बारण करुथला. बणा एवं तार ससुर हेम नायक उभय मिसी भरत को ठेंगा प्रहार कले. तार गोड़ मध्य पटिया कपड़ा होइछि.
भरत नायक पीडब्ल्यू.
भरत नायक पीडब्ल्यू
10.
घटना समय तार गोड़ खंडिया खाबरा होइछि घटना समय आम गाँव आहुरी श्री भरत नायक श्री सुरेंद्र मल्लिक एवं अन्य माने मध्य देखिछन्ति
भरत नायक PW10 सुरेंद्र मल्लिक एग्जाम नहीं छी
Yes,
PW3
श्री सुरेंद्र मल्लिक एवं अन्य माने मध्य देखिछन्ति एहापरे मु जाई श्रीजुक्त लंबोदर पंडा तांका पुओ श्रीजुक्त विजय पंडा को घटना संपर्क रे एवं फोन जोगे थाना को खबर देबा पई जणाइली
in this case there are eyewitnesses to the occurrence. Who are the eyewitnesses?
PW1
PW1
C.
PW1
7
4
7 go 1 for a 3
then 4
PW4
then 7
PW7
then 9
PW9
then 10 11
PW10 and PW11.
Yes.
Who is the doctor who conducted PM?
PW14
PW14. आपण आगे PW14 को पढ़े सुन तापर जीवा eyewitness. PW14 evidence को सुन. Page number होची 98.
सुधीरंजन दास
Dr.
Sudhiranjan Das.
Sudhiranjan Das.
On 15/4/2002, I was attached to DHH Baripada. On that day, I conducted the autopsy on the dead body of Sarthak Malik, son of Gambira Malik, at 2:10 p.m. The dead body was identified to me by Police Constable A.K. Kanara Babu. My findings are My findings are as follows. External appearance. Average body build. Rigor motifs were present on the lower limbs only. Bleeding from both the nostril and mouth. Injuries. One incised wound of size 7 cm into 2 cm into bone tips over the right side of skull over the vertex. An abrasion of size 8 cm into 2 cm over the left side of the chest. Third, internal appearance.
Injury to Mr. Tripathi, that is attributed against that MO.
Yes.
Right?
Yes.
I would have abrasion to left side. All right. The other appellant is stated to have assaulted by lathi blows. Okay. Internal appearance.
On dissection of the skull, I found the skull bones showed linear fracture about 10 cm in length extending from the injury MO1 to the orbit of the same site. A clot of size 3 into 2 into 1 was overlaid over the fracture. On opening the skull, a large hematoma of size 4 into 2 into 1 was present below the
4 inch into 2 inch into 1.
Was present below the fracture site, compressing the brain matters. On removing the brain matter, the middle cranial
fossa showed linear fracture.
Other viscera were pale. The stomach contained semi-digested food and gas. Small intestine contained semi-digested food and gas. The large intestine contained fecal materials. All the above injuries are antemortem in nature. The cause of the death is due to injury to vital organ like brain. Time since death was within 24 to 36 hours at the time of my postmortem examination. This is my postmortem examination report marked Exhibit 9 and Exhibit 9/1 is my signature therein. Then 4, para 4. On 17/5/2002, on the requisition of the police officer, I examined one lathi and one kuradi sent by IO with reference to my report, Exhibit 9, and I opined that the injury number 2, that is an aberration on the deceased could be possible by lathi. The inside wound found on the deceased could be possible by kuradi. That is X bracketed X. This is that kuradi which has been marked as MO1, and this is Kendu lathi which has been marked as MO2 Exhibit 10 is my report, and Exhibit 10 by 2 is my signature. Cross-examination by defense. The aberration found on the deceased could be possible by rubbing against the hard objects. The incised wound are usually caused by sharp objects. It may be possible in any accident, including the vehicular accident, if the body comes in contact
with the sharp object.
Contact with any sharp objects. Paragraph 6. There was a stain on the sharp side of MO1. That stain is no more visible on MO1 now. I cannot say how many blows were inflicted on the deceased. As there was only one incised wound, I presume that there might be only one blow dealt on the deceased by the sharp cutting object. Also, I cannot say how many blows were dealt on the deceased by the lathi MO2. The deceased could have been survived and had the medical facilities for neurological treatment would have been made available. On the basis of my findings of rigor mortis, the other features I opined that the death might have been caused between 24 to 36 hours of my PM examination. It cannot be ruled out that the death might have also been caused within 22 hours of my examination. It is not a fact that PM examination is perfunctory and my opinions are not correct.
So this is the evidence of the doctor. Now you come to the PW1
to see.
All the eyewitnesses have supported the prosecution case.
Yeah.
Come to PW1. PW1 बाहर करोगे. Page number 61.
I know both the accused person, deceased my husband. The occurrence took place last year on one Sunday during the summer season. At about 4 p.m., accused Santosh Malik came near our house being armed with a kendu lathi and abused my husband in slang language, saying that. Accused Hema was also
with a budia.
X and shouted at my husband. As my husband asked why they abused him, accused Santosh assaulted my husband by means of thenga and gave blow on him abruptly on all the parts of his body. Accused Hema dealt a blow by means of a budia on the left side head of my husband, which caused bleeding injury. My husband fell down on the ground due to assault. I raised halla. Hearing my halla, my younger brother, Batua came. Some of Batua came. Some other villagers also came to the spot. One Lambodara Parida, Chandrasekhara Patti, and other came to the spot. I arrived at the Betonati police station and presented the written report there. My report was written down by my brother Patua to my dictation and put my LTI there after framing the correspondence of the same. My husband died at the spot.
Mr. Tripathi, just mark one thing.
Yes.
About this assault which has been stated to have been made by the Santosh.
Yes. All over the body.
By means of a thenga abruptly on this goes contrary to the
medical.
Okay.
Indiscriminate assault ହେଲେ ତ ସବୁ
On different parts of the body, all parts of the body. That is the evidence of other eyewitnesses also. देखी ना. Let us, we'll go to the cross-examination on this aspect. Let us go to the another eyewitness. Then, a particular contour. No, we'll go
Surendra.
just Surendra. He
Surendra, 71.
same thing. Sarat Malik assaulted by
Surendra Malik.
means of Henga. এটা হচ্ছে সন্তোষ
I saw the accused Santosh Malik assaulting by means of his
All right, come to the cross-examination. Of PW1.
House of the accused persons is at the audible range from my house. One Chandra Naik, Pratap Naik, Balai Naik, Surendra Naik, Chaturai have got houses near my house. Accused persons are my front door neighbors. Makra Machi and Chopra Machi are also my immediate neighbors. All of them were present in their respective houses at the time of occurrence. They came to the
spot soon after the occurrence.
Soon after the occurrence, they reached the spot at about 8 p.m. Police officer arrived at the spot at about 7 p.m. I went to the PS alone to lodge report. I cannot say the distance from my village to Betanati PS. It is true that one will take 3 to 4 hours to cover distance from my village to the PS. My brother followed to the PS. I left the PS before the arrival of my brother. I met on the way near Badajodar. At that time, nobody was present. The police officer updated my LTI on paper near my house. I verbally reported the matter to police officer, which was reduced into writing by him. It is not a fact that the contents of the report reduced into writing by police officer was not read over to me. The occurrence took place of the day of Sankranti, which is locally known as Chhatua Sankranti. Neither myself nor my husband took handia on that day. There is no animosity between the accused person and my husband.
Pause for a moment. Mr. Tripathi, in the chief examination, this lady says, this man says that he went to the police station. I arrived at Betanoti police station, page 62.
Yes.
Fourth line, presented a written report, and the report was written down by my brother to my dictation, and I put the LTI. Now you come to the cross examination, just she read now.
That is 64 page.
Page 9. See the next page. 63 hour. The police officer obtained my LTI on a paper near my house. I verbally reported the matter to the police officer, which was reduced into writing by him. It is so perhaps মানে কোউঠি
କିଏ ଲେଖିଲା
ସେଟା ବି କଣ୍ଟ୍ରାଡିକ୍ସନ ହଉଛି ଆଉ କୋଉ ଜାଗାରେ ଆକ୍ଚୁଆଲି ଏଫଆଇଆର ଟା ତାକୁ ଦିଆ ହେଲା ଚିଫ ରୁ ଜଣା ପଡୁଛି ପୋଲିସ ଷ୍ଟେସନ ରେ ଦିଆ ହେଲା whereas କେରାରୁ ଜଣା ପଡୁଛି ଯେ ଏଟା ବୋଧେ ମାନେ ଘଟଣା ତା ଗାଁରେ to the PIGA. All right, next you come to that. Paragraph 4.
There is no animosity.
No animosity between the accused person and my husband. We have normal relationship as co-villager. The place of occurrence will be about 100 cubit from my house. It was already sunset when the occurrence took place. It is true that I have stated in the FIR that my husband was going towards the house of one Pratap Naik from our house. The fact which I have stated in court that my husband was assaulted when he came out is not correct. The facts which I have stated in the FIR is correct. At the time of occurrence, my niece Sulochana was present in the house. I came out of the house after hearing noise outside. I saw the accused person and my husband tussling. At that time, none else except myself was present at the spot. Both the accused persons stay in one house. I did not intervene in the tussle. At the time I arrived,
My husband and accused Santosh
were tussling. Accused Hema,
Emma dealt a blow by Budia.
Spot at a short distance. I cannot stood at the spot at a short distance. I cannot say the size of the thenga held by accused Santosh. Accused Santosh dealt the blow in quick succession and abruptly on the body of my husband. I cannot say the number of blows dealt by him. My husband all of a sudden fell down due to the blow by lathi and lost his sense. I myself and Sulochana tendered water to my husband. I left for my home thereafter. I called the neighbors to the spot soon after the occurrence. Some of them also tendered water to my husband, but he could not receive. Paragraph 5. The accused persons left the spot after the occurrence. They went back to their house. We didn't immediately remove my husband to the hospital. We took him to the hospital, Baripada, on the following day at about 12 o'clock. I was examined by police during investigation and my statements have been recorded. It is not a fact that I have not stated before the IO that accused Hema dealt a blow by Budia on the left side head of my husband. It is not a fact that I have not mentioned about the same in the FIR. It is not a fact that I have not stated before IO that Mokara Maji, Chakra Maji, Surendra Naik, Chandra Naik, Pratap Naik, Balia Naik were present in their respective house at the time of occurrence and they came to the spot soon after the occurrence. I went to a distance to call Surendra Naik and others telling them that accused Santosh had assaulted my husband. Accused Hema dealt a blow by Budia at that time. The villagers did not confront the matter with accused Hema at the spot. I had also no occasion to ask him regarding assault. Nobody had snatched the Budia from accused Hema. Soon after seeing the ghastly scenes, I myself lost my sense. It is not a fact that I deposed falsely and that I have not seen my assault on my husband.
I have not seen any assault on my husband.
Assault on my husband. It is not a fact that I deposed falsely, authorized by police, tied to my dictation. And corrected
you lined paragraph 5 from third line page 65.
We did not immediately remove my husband to the hospital. We took him to the hospital Baripada on the following day.
Following day মানে 15 তারিখ বোধ হয়। কারণ এই
হ্যাঁ,
ঘটনাটা
14
হচ্ছে
তারিখ
14 তারিখ।
14 ତାରିଖ 15
ମାନେ
ତାରିଖ 12ଟା ବେଳେ
ଇଏ ଡିସିଜ ଡେଥ୍ କୋଉଠି ହେଲା?
ହସ୍ପିଟାଲ
କେବେ?
ନାଇଁ ଡିସିଜ ସ୍ପଟରେ କହୁଛନ୍ତି, ସାକ୍ଷୀ କହୁଛନ୍ତି ସ୍ପଟରେ।
ବଟ୍ ଏଠି ମାନେ କଣ ଡେଡ୍ ବଡି ରିମୁଭ୍ କରିବା କଥା କହୁଛି ନା କଣ? We did not immediately remove my husband to the hospital. We took him to the hospital to Baripada on the following day. Dead body ହେଲା ତ ଇଏ ହେଇଥିବ ନା, ଇନକ୍ୱେଷ୍ଟ ହେଲା ପରେ ତ ଯାଇଥିବ। ଚିଫ୍ ରେ କହିଲା ଯେ my husband died at the spot.
Yes,
that is it. But ଏଇଟା ଏଇ ଯୋଉ ଲାଇନ୍ ଟା କହୁଛି,
We did not remove it.
we did not remove my husband to the hospital. We took him to the hospital so and so. ଟିକେ
ତା ପରଦିନ 12ଟା ବେଳେ ବୁଝାଲେ।
ହଁ ନାଇଁ ନାଇଁ ସେଟା ଡେଡ୍
That
ବଡି
might be after the inquest.
ନା ଡେଡ୍ ବଡି ହସ୍ପିଟାଲ
ମାନେ ଯେମିତି ଜଣା ପଡୁଛି ମାନେ ଆମେ ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ ନେଲୁନି, ତା ପରଦିନ ଆମେ
ଏଇଭଳିଆ ଜଣା ପଡୁଛି।
ସନ୍ଧ୍ୟା ହେଇଯାଇଥିଲା ଆଉ ଗାଁର
ଦୂରତା ଦୂର ବି ଅଛି। That could be, but ଅନ୍ୟ ଜଣା ପଡିବ।
ଅନ୍ୟ କାହିଁକି ନା ଯଦି
PW2 ଇନକ୍ୱେଷ୍ଟ ଉପରେ କହୁଛି। ଆଜ ପେଜ 67
ଇନକ୍ୱେଷ୍ଟ କେତେବେଳେ? ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ଟା ଟିକେ ବାହାରିଥିଲା ଦେଖିଆ। ଏଇଟା କଣ
ଫୁଟା ନାଇକ ଯୋଉଟା 66 to 70 तो मैं go through
Yes.
I know both the accused person
ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ହେଲା ଏଇଟା 15/4/2002 ରେ ଇନକ୍ୱେଷ୍ଟ ହେଇଛି 15/4/2002 8 AM ସକାଳେ ସକାଳେ ତାମାନେ 12ଟା ବେଳେ ଯୋଉ ନେଲେ ପୋଷ୍ଟମର୍ଟମ ତାମାନେ ସେତେ ନିଆ ହେଇନି ଆଉ। He has not been shifted for treatment. ଏଇଟା ହେଇଛି identified लोधा साही ଭିଲେଜ ଧନସୋଲ ଫ୍ରଣ୍ଟ ହାଉସ ରାସ୍ତା ଉପରେ ଲୋଧା ସାହି ସ୍ଥିତ ଭାୟାମଳିକ ଘର ସାମ୍ନା ସରକାରୀ ରାସ୍ତା ଉପରେ ମରି ପଡିଥିବାର ପାଇଗଲା। ସେଇଠି ହିଁ ଅଛି ସ୍ପଟରେ, ପଞ୍ଚାୟତ ରାସ୍ତା ଉପରେ।
ये ଦେଖନ୍ତୁ occurrence of offense जो डेट दी है 14/4/2002 at about 9 टाइम ଟା ହଉଛି 4ଟା ବେଳେ। କିନ୍ତୁ ଯୋଉ ଇନଫରମେସନ ରିସିଭ ସେଠି ଏଇ ଘଟଣାର ଇନଫରମେସନ 14/4/2002 6:30 at the spot କହୁଛି। ତାପରେ ସେଇଟା ପୋଲିସ ଷ୍ଟେସନ କୁ
15/4 ଲେଖା ହେଇଛି ଇନଫରମେସନ 15/4
ହଁ 15/4/2002 ରେ ଥାନାରେ ପହଞ୍ଚି ରାତି ରେ ସେ FIR
distance is 30 kilometers
30 kilometers। ତେଣୁ ସେ ଯୋଉ ୱିଟନେସ୍ କହୁଛି ମୁଁ ଯାଇ ଥାନାରେ ଏତଲା ଦେଲି ଏଇଟା ଠିକ ନୁହେଁ। କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଠିକ ହୋଇଛି ଯେ ଘଟଣା ଜାଗାରେ ମୁଁ ସିଏ ଇଏ କଲା ସେଇଟା ଠିକ। ଚିଫ ଏକ୍ସାମିନେସନ ରେ କହୁନି ପ୍ରଥମେ ଯେ ଆମେ ଥାନାରେ ଯାଇ ରିପୋର୍ଟ ଦେଲୁ ମୋ ଭାଇ ନା କିଏ ଲେଖିଦେଲା,
ଭାଇ ଲେଖିଲା।
ହଁ that is not chief examination. I arrived at the Betanodi police station, presented the written FIR. My report was written down by my brother and then so on. That is not correct.
Yes.
ये जो चीज क्रॉस एग्जामिनेशन में कहूची police officer obtained my LTA on a paper near my house. I verbally reported the matter so and so, which was reduced to writing by him. That is that appears to be
correct.
Correct. कौन लग रहा है ଆପଣ यार चीफ टा पढ़ी देले तो सब तो
हां PW1
PW1
we will continue tomorrow
yes
है ना गाने सजा कर ଏଇଟା ସରିଲେ ଆପଣଙ୍କର ହେଲା ରେଡି ଆଉ ସେଇଥିରୁ ଦେଖି ଆର୍ଗୁମେଣ୍ଟ କରିବି ହଁ ସେଇଟାକୁ ସାଇଡରେ ରଖିକି
ଆଜ୍ଞା ଆଜ୍ଞା
ତୁ ଅଭ୍ୟାସ ହେଇଯାଉ